From hearing item 1 to 5.
Please, this honorable court.
Yes.
Lords, these are 5 habeas corpus petitions, minutes, which were filed in 2020.
If your lordship, that day I was halfway through on the question of repugnancy.
No, he's on some other.
No, it's all right. And lordship asked me to give a gist of the arguments. I have brought it, my lord, preliminary.
Yeah. We'll call up the matter now.
Yes.
Some other item. Yes.
And Lords, in the past, your lordships have been parts of 2 different benches, respective benches, Lords, which have passed substantive orders in this matter. In fact, my lords, this matter ought to have culminated much long ago. However, my lords, because of some reason or the other.
So what is the issue now? Live issue?
Yes.
What is the live
The
issue?
live issue, my lords, is the antecedent illegality, which was in the orders, 3 impugned notifications, which had designated the 6 district jails of the state as temporary detention centers. That is 1, my lords. And second, my lords, there are prayers in our petitions, all the 5 petitions, for issuance of writs in the nature of certiorari and mandamus by this honorable court, declaring those 3 notifications as unconstitutional and illegal. The habeas corpus, my lords, the habeas corpus prayer, what has happened over time is that the state consistently had this stand that we are constructing Matia detention center, which is going to cater solely to foreign nationals. So it's going to be a detention center which is in line with all the central government directives from 1998, which say that detention centers have to be suitable. They have to only cater to foreign nationals and not to anybody else. They have to be outside jail premises. Now, my lords, what happened, and we had brought this to the notice of the honorable court by an affidavit filed last year. After Matia was completed, my lords, the state government passed another notification by which they declared Matia as a temporary jail. This happened when in the state, my lords, there were numerous arrests which were carried out within the span of a very short time for the protection of children from Child Marriage Act, my lords. And those people were housed in Matia because it was made a temporary jail. In doing that, my lords, our humble submission before this honorable court last year was that the issue revived. Because what the state is doing, my lords, ultimately, is that in 1958, my lords, there was a conditional delegation, conditional entrustment of power by the union under Article 258, which said that the union will stipulate conditions under which the liberty of foreign nationals can be curtailed. The conditions under which they can be detained. The state, my lords, by means of the 3 impugned notifications in all of these petitions, initially, they breached the conditional entrustment. And then, my lords, last year, by doing something indirectly, which they're prohibited from doing directly, they again breached the conditional entrustment. Therefore, my lords, the issue revived itself. In a crux, my lords, that is our case. My lords, in seriatim.
What is the relief that petition? You are appearing in all the petitions.
Yes, in the 5 petitions, my lords.
What is the relief that is being sought?
Indeed, my lords. So I may take your lordships to the prayer.
Please
Yes.
tell us.
Yes, my lords. The first thing, my lords, is a writ of in the nature of habeas corpus, my lords, for release of all of these detainees who were being detained in temporary jails at the time when the writ petitions were filed. Because the designation of
How many detainees are there?
yes, my lords, in all of these petitions, my lords, the number of detainees who are being represented are different, my lords. In item number 1, my lords, it deals with 5 women detainees who were
5?
housed in central, 5 female detainees, my lords,
Female.
who were housed at the central jail, Jorhat.
Yes. Then
Writ petition criminal number 3, my lords, that's Nurud Zaman Diwan. Yes, my lords.
item number 2.
That's item number 2, my lords. Was this one there?
How many detainees?
Yes. Item number 2, my lords. There are 2 detainees, my lords. 2 detainees in district jail, Gwalpara, my lords. In item number 3, my lords, that's Deepika Sarkar, that is the illegal detention of 1 detainee, my lords, at the state jail in Gwalpara, my lords. In item number 4, my lords, 44 detainees at district jail, Gwalpara. And in the last item, my lords, 68 declared foreign nationals in the district jail Gwalpara, my lords.
So all these persons have been declared as foreign nationals.
Now, my lords, in the
No, yes or no, say
yes,
that.
my lords,
That
there's one
declared-
distinction, my lords. Some of them are convicted foreign nationals and some are declared foreign nationals, my lords.
Convicted foreign nationals.
Yes, my lords.
What does it
Convicted
mean?
foreign nationals, my lords, there are some people who have been convicted under some of these acts for offences, my lords,
Hmm.
for illegal entry, let's say for NDPS and all also, my lords. And after the term of conviction ends,
Hmm.
they are still, my lords, languishing in the temporary jails. So therefore, the term convicted foreign nationals and declared foreign nationals, my lords, the Citizenship Act procedure, my lords, that has been followed.
So FT has given an opinion that they are
Yes.
foreign nationals.
Yes.
Any writ petition or any other proceeding filed against the opinion of the FT?
My lords, in all of these cases, my lords, in some of them they were pending, my lords, in others, my lords, no.
In other words, you are not aware.
No, my lords, I'm not aware of each of the cases, my lords. I'm sorry, my lords.
Now, all these people are at the moment housed in the Matia detention camp
Yes, my lords.
center.
Yes, not
Correct.
all of them, my lords, some of them, because some of them were released during COVID, my lords, because of the bail order which was passed by the Honorable Supreme Court in the suo motu proceedings.
So those are released, they are still out,
Yes, my lords.
and the remaining are still in detention.
Yes, my lords.
How many of them are in detention?
My lords, that the state is aware, my lords, because we have not been given that information, because there is no pleadings to that effect. How many people are there in Mathia, my lords? There's no pleadings.
So today, what do you want in these proceedings?
My lords, yes. Insofar as the detention of these people in Mathia is also concerned, my lords, because the issue got revived last year, because they termed it as a temporary jail, my lords. Therefore, the habeas corpus prayer, in my humble submission, my lords, is still alive. Because, my lords, a detention center can only be a detention center. It cannot be half a jail or half a detention center, my lords. In my humble submission, my lords. And insofar as the 3 notifications are concerned, my lords, which we have impugned in all of these 5 writ petitions, in my humble submission, my lords, these...
You want a writ of certiorari
Yes, my lords.
in a
insofar-
habeas corpus petition?
Indeed, my lords. My lords, we have separate prayers my lords, in
No,
all of
that's
these
all
petitions.
right.
Yes.
But these are all writ petition criminal.
Yes,
These
yes,
are all meant for issuance of a writ of habeas corpus,
my lords.
right? Certiorari is another proceeding. It's a different nature of it. It's a writ petition where the court has to invoke certiorari jurisdiction.
My lords.
So is there a prayer for issuance of a writ of certiorari?
Indeed, my lords. In item number 1, my lords, would kindly have the prayer.
Mhm.
It's housed at page number 26 of the writ petition, my lords.
Page number 26. Just a moment. Yes.
Yes, my lords. The prayer A, my lords, is a prayer for habeas corpus, my lords. Insofar as the other prayers are concerned, my lords, my prayer for certiorari, my lords, it's at prayer B at page 27, my lords. Prayer A, my lords, if I may read, the court may further be pleased to issue a rule upon the respondent authorities to show as to why a writ in the nature of habeas corpus should not be issued, directing the state respondents to set the detainees at liberty from the illegal detention in state prisons caused to them by the state respondents, with a further direction to comply with the circulars dated so and so, so and so, and so and so, issued by the Ministry of Home Affairs, Government of India, as mandated by the Honorable Supreme Court by orders dated 28th of February 2012 in writ petition criminal number 310 of 2015, titled so and so, and order dated 2nd of November 2018 in ISO and so in WPC so and so in inhuman conditions in 138 prisons, my lords. This is my habeas corpus prayer, and the consequence, my lords, or in fact, my lords, the foundational fact which I will have to establish in the course of arguing that the habeas corpus writ or a writ in the nature of habeas corpus be issued by the Honorable Court would be that, my lords, these 3 notifications would have to, I would have to impugn them, my lords. Even otherwise, if my prayer before this honorable court is that these notifications of the central government ought to be complied with. In doing so, my lords, ultimately, these three notifications, my lords, which were issued by the state, designating those 6 jails as temporary detention centers, those I would have to impugn, my lords. Because ultimately, my lords, the validity of the detention in those centers, that is what is in question in my humble submission before this honorable court. Therefore, my lords, those are impugned. Even if, my lords, even if I assume for a moment, my lords, with your kind permission, that these notifications were not under challenge before this honorable court today. Ultimately, my lords, in the course of my arguments before your lordships, I would have to impugn them in some way or the other, saying that they...
But that's fine. So today you are arguing finally,
Yes, my lords.
but you don't know who has been released. Without that, we will not
Yeah.
pass any order.
My lords, insofar as that is concerned, my lords, what had happened is that when this matter had come up after Matia, the transfer to Matia was done, immediately, my lords, in February last year, that issue happened that they made it a temporary jail and almost 1,500 people who were arrested, they were shifted there. Criminals. There's an order of this honorable court which was passed last year, my lords.
Is it the only ground that the notification turns into a temporary jail? And therefore, but you are not alleging that there is violation of Bhim Singh's judgment in the condition of these detainees, insofar as the Matia detention center is concerned. That is not your argument.
There is, my lords, indeed.
That is your argument.
It is, my lords, because in Bhim Singh, my lords, what had been held by the Honorable Supreme Court, my lords, in my humble submission, is that detainees cannot be kept in jails. That is what was held in Bhim Singh.
We understand.
Yes.
We put all of them in Radisson Blue and
Yes.
name it as Radisson Blue Jail.
Yes.
You are complaining about that? Or we put them in a detention center which is worse than a jail, but we don't name it detention jail. So you are happy. Is that the remit of your argument?
Only they should be housed there, my lords. Nobody else. That is my argument, my lords. Only the foreign nationals ought to be housed there, not anybody else, my lords. Their argument, the state's argument, was an argument of convenience. That because it is inconvenient for us at this moment to house these other criminals whom we have newly arrested in different jails of the state, therefore we are housing them in Matia because Matia can house 3,000 people. And their argument was that only 100 odd
No, but
foreign
how are
nationals
you
are there.
affected? Is it a common facility for the?
Yes, my lords. It's a common facility, my lords. It's 1,500 men and 1,500 females, my lords.
No. Amongst the detainees and the under trial prisoners, is it a common facility shared by both the groups?
The instructions which they placed before the state placed before this honorable court, my lords, according to that, it's not, my lords. They were housing the criminals in some other tower and the foreign nationals in some other barracks, my lords.
Then how are you affected?
My humble submission, my lords, is that insofar as this distinction is concerned, my lords, it still goes on to violate constitutional principles, my lords. Because
Right,
under
you have a point.
Yes.
We'll tell them to give two different names to the one part where the jail under trial prisoners are there. They will name it as jail. The other part they'll name it as detention center. That's the simple logic.
lords,
Are you agreeable to that?
my
We'll
lords,
pass an order just now.
no, my lords,
If
my
the
lords,
name is the only problem, then we'll tell them to clarify. That's all.
my lords, it's the infrastructural setup, my lords, that insofar as the foreign nationals are concerned, the infrastructural setup in which they are being detained, that ought not to be, and in my humble submission, my lords, should not to be held to be the same, where other people can also be.
They're asking you,
Yes.
is the facility common and shared by both categories, or are the facilities different?
No, my lords. They're shared in the sense, my lords, Matia, it has different towers, my lords, different barracks. The infrastructure is such that, my lords, it's like this is one room and there is another room. Sorry,
The infrastructure in Matia, which is lying vacant,
my lords.
that infrastructure they are using to house the under trial prisoners. So by using that analogy, you are saying that they have turned the detention center into a jail.
Yes, my lords.
We'll hear it in due course. There's nothing, no urgency in this matter. How can you be prejudiced with that? Unless you say that you are being subjected to the same standards, lifestyle, or rigors of that of an under trial prisoner. You can't have any grievance for that.
We are, my lords. That is our case. Because, my lords, if there are people who are being housed in the same facilities as us, we are being subjected to the same facilities as these people who are inmates in prisons, my lords.
Who is appearing for the state here?
My lord, Mr. Deenat, senior government advocate, is appearing in the matter, and he may complete his hearing if
No, it's over. We have heard him. You make your arguments now.
we need some time
We will not,
for
we
accommodation.
did not make that prayer in the beginning.
My lord, in that case, for the time being, I may
Where
be.
is Dina?
He's on legs in court number 1, my lords.
Then some other counsel has to come. You can't make the court wait.
My lords.
So you make your submission or we'll close the
My
matter.
lord, it may be taken up after some time, my lord.
Once the matter is, we have heard it, not postpone it. Segregate it. You give a separate nomenclature, separate facilities for detainees, foreign national detainees, and
My lords, there are otherwise 11 towers
Hmm.
at Goalpara Transit Camp, which are presently being occupied by the declared foreign nationals and under trial prisoners under PCM and POXO Act. Out of those 11 numbers of completed tower, 3 numbers of towers are designated for keeping the DFNs. And the remaining 8 numbers of towers are designated to keeping the inmates UTPs under PCM and POXO Act.
so foreign nationals, 3 towers are designated.
Yes, my lord.
So these are separate facilities, is it?
Yes, my lord, separate facilities.
No, my lords, they're
You
not.
close it. You can approach the court if you have a specific grievance. Habeas corpus is over.
My lords, insofar as that is concerned, my lords, if my humble submission there, my lords, is that first, my lords, the antecedent illegality may be indulged, my lords, by this honorable court. That for years, my lords, from 2009 till 2020,
But you don't have the pleadings here.
I do, my lords. The pleadings are there, my lords. In the habeas corpus petition, my lords, there are 3 notifications which we are concerned with, my lords.
You don't have post-Matia construction pleadings.
Yes, my lords. Post-Matia
So
construction,
you're taking a risk if you want to argue this matter.
that is true, my lords. My lords,
If that is true, then what is,
my lords,
let the truth take its own course.
my lords, instructions are incomplete as insofar as that is concerned, because how
Mr.
many people,
Sharma,
my lords?
the circumstances under which these habeas corpus petitions were filed were totally different.
Yes,
That was the time when all these detainees were housed in the jails,
yes,
regular jails.
yes,
Therefore, this action was clearly on the teeth of Bhim Singh, was unsustainable.
yes, my lords.
After these petitions have been filed, notices are issued, the government has come and taken stand that they will be shifted very soon. Matia Detention Center was constructed. These people have been shifted. Some of them have been allowed to go on bail. Some of them are still there.
Yes, ma'am.
But out of the 11 towers, as she is saying, only 3 towers were required for housing the detainees.
Yes,
Therefore, the remaining 8 towers they are using for putting the
Under
under-trial prisoners.
yes,
These facilities are separate. Therefore, part utilization of the facilities
yes,
for other purposes without affecting the regular, routine activities, day-to-day life of the detainees. We don't see any reason how we can exercise our jurisdiction of habeas corpus, because otherwise the detainees are required to be kept in detention. Habeas corpus will be applicable only when they are in unauthorized. The person is unauthorizedly detained.
yes,
This is not an unauthorized detention. The detention is on the basis of opinion of the foreigners tribunal or conviction by the courts. These are not unauthorized. These are detention as per law. The basic issue is whether the conditions in Matia are one or such which are in consonance with the guidelines in Bhim Singh. For that, you don't have any pleadings because your pleadings are pre-Matia. So we are asking you simple question. Why don't we close it by giving you the liberty to close the court with a specific grievance if and when the occasion arises? Otherwise, on that finding, we have to close these petitions.
my lords.
You can't keep dragging it.
Certainly, my lords.
So
That's
you
I-
have to take a decision on that.
Yes. Let's, insofar as
And
my,
you have 3 minutes to do that.
yes, my lords. Let's, insofar as my, I appreciate it. I'm grateful.
Yes.
My lords, insofar as my pleadings are concerned, it's my duty, my lords, only to point out to your lordships. I have an additional affidavit which I had filed, my lords, on 27th of February last year, which is at page 139 in the first matter minutes, where we had brought this honorable court to notice that this is what is being done with Matia. There was a notification which the state government had passed, Millets, by which it was simple, Millets. They said, we notify a part of the transit camp, Matia campus, comprising of 8 blocks as temporary jail until further order. Thereafter, Millets, what has happened is the instruction which my learned colleague has read out. This is an instruction of 13th of March of last year, where they have said that there are 217 declared foreign nationals who are being kept in one part of Matia. And then they are saying that there are 11 towers in Gwalpara transit camp in total in Matia. Out of the 11, 3 towers, three of the towers are designated for declared foreign nationals, and the remaining 8 are for these people who are under trial under the PCM and POCSO. In my humble submission, Millets, what was happening previously, and it was only, this may seem like a theoretical distinction, Millets, I'll say this at the outset myself, because of the lack of numbers from my side. However, Millets, my humble submission is, in the past, what they were doing is that they had jails, and they made a part of those temporary detention centers. Now they have a detention center, and they're making a part of that temporary jails. The indictment, they indict under 258, read with Article 257 of the Constitution, strikes down at this act also, Millets. That is my humble submission, that if you have a detention center, Millets, which is meant only to be a detention center, that ought not to be designated as a temporary jail either. That is my humble submission. Insofar as the numbers are concerned, Millets, I humbly apologize, Millets. I do not have the numbers because they're not accessible to me, Millets. How many people are there today inside and how many people are not there, Millets? I don't have that number, that information for the Honorable Court. That information they would have, Millets. However, Millets, my humble submission is that today, if there is a infrastructure which is supposed to be designated as a detention center, it may have 11 towers or 110 towers, and it may house only 2 foreign nationals. But, Millets, it is not up to the state government to say that for me, it is convenient to house thousands of other people who ought to be in jails in these detention centers, merely because the infrastructure is lying empty, Millets. Because, Millets, that direction has to come from the union government first, Millets, under 258. They do not have that.
Mr. Sharma, we appreciate your argument. You are arguing in a lot of sense and stability, but please understand what we are asking you is, habeas corpus part is over now. The detention of these foreign nationals are on the basis of court orders,
Yes.
or orders of the FT. If your grievance is pertaining to the setting up of partial conversion of it into, that is a completely different matter.
Yes.
That will go out of the remit of these proceedings. So if you want to agitate it, you may very well do it. Then your arguments, your trust of your arguments will be completely different.
Yes.
That will go into the, inner vicissitudes of Article 21,
Millets.
which we are willing to hear.
Millets.
But then the litigation cannot have an amorphous journey.
Millets.
It started with something that
Millets.
released us from jail.
Millets.
Our detention in jail is illegal because we are not criminals. This cannot take a complete U-turn, and then that will be a never-ending exercise. Therefore, we'll close it today. You can, 1.5 minutes is gone, 1.5 minutes.
Millets.
You can tell us what you want.
Millets.
If you want us to close it with a short order, we can do it, or we'll pass a detailed judgment, in which case liberty will not be given. Next round, you will have to make out a case. What do you want? Because after we give a detailed order, we cannot give you liberty. Mr. Nath, is that the issue now?
No, otherwise, Lordship, I agree with your Malada, that the grievance raised in this petition that has been meted out, and the issue now he has raised, it was because of a particular peculiar situation at that point of time. Some
That situation,
that
whether
is
it
over.
Violative or not, we need the.
Yes,
pleadings.
it is not
We need
in
the materials
question.
Which are not
It is not in
here.
question here, Malad. It is not in question, and number 2 is Malad, that is over. That is by now it is over.
That's the instructions that I have. Is that, Millets, the matter may be closed, Millets. Your Lordships may pass a judgment.
We
However,
get liberty.
Not on that limited ground, Millets.
Huh?
Not on that limited point, Millets, that the matter has become infructuous at this point. Because my argument, Millets, is this, my humble argument, Millets, is that the illegality which was being committed earlier, since 2009,
No, but it will be open for the petitioners or any aggrieved person to question the present setup in the detention center insofar as the same throws open a part of the as many as 8 towers to regular under trial prisoners and any other ancillary issue. That's what we'll observe. That's all. That issue, if it is raised, we'll examine it.
Lordship.
Millets. Millets, in fact, because they, although they are saying, Millets, that the issue is now over,
Correct.
You want to argue on merit?
Millets, if
No,
since
no,
there is no,
Don't feel inhibited. You argue, but in that case, we'll pass an order on merit. There is no question of liberty. Either you succeed or you fail. As simple as that. But if we don't express our opinion on the issues, then the liberty will automatically be there. So you can choose what you want.
Millets.
What do you want?
There's the pleadings actually, Millets, there's nothing on record from their side also, Millets, to say that the this issue is over, Millets, but my senior colleague is saying that, so Millets, the court will go by that. However, Millets, any reasoned order that the honorable court deems it fit to pass, Millets, if liberty is also granted, it's only this issue, Millets, that the legality of the detention in Matia presently also, Millets.
Bhim Singh versus Union of India. Bhim Singh versus Union of India, 2012, bracket 2, 13 SSC 471. Paras 5 and 6. Just keep that. All right. So we're passing the order.
Millets.
Heard Mr.
A. Gautam,
A.
Millets.
Gautam, learned counsel appearing for the petitioners in this batch of writ petitions, bracket criminal, bracket close. Also heard Mr. D. Nath, learned senior government advocate Assam appearing for the state of Assam, as well as support the Vijay Gayan, learned CGC appearing for the Union of India, as well as Mr. These 5 writ petitions, bracket criminal, have been preferred on identical fact situation, comma, seeking similar reliefs. Stop. The writ petitions have been preferred by socially active persons espousing the cause of a number of detainees who were housed in the district jails of Jorhat and Walpara on being declared as foreign nationals, either on the basis of opinions rendered by the foreigners tribunals in Assam or on being convicted by the competent court of law due to offences committed under, which are the act offences committed?
Maybe various acts, Millets, NDPS, Citizenship Passports Act, Millets, there's no specific.
Convicted in India.
By the foreigners tribunals, full stop. Some of the detainees are foreign nationals who have also been convicted by various courts in India for committing offences under the NDPS Act, as well as many other legislations in force in India.
Some are declared foreigner, some are convicted foreigner.
Full stop. In other words, some of the detainees are declared foreigners, whereas the others are convicted foreigners. Full stop. Be that as it may, considering the fact that all these detainees were housed in regular district jails, and in view of the guidelines laid down by the Honorable Supreme Court of India in the case of Bhim Singh versus so-and-so, the present petitions have been these detainees since their detention in district jails was contended to be illegal, full stop. The petitioners have also challenged the notification number PLB.149/208/50 dated 01/12/2009, notification number PLB.149/2008/54 dated 5/4/2010, and notification number PLB.121/2015/44 dated 24/09/2015, with a prayer to declare those notifications as unconstitutional. What are these notifications about?
Those notifications are, some portion of the jail, those are segregated and treated to be detention center. By those notifications, those are challenged.
On the ground that these notifications have illegally designated parts of the district jails as detention centers, thus contravening the fundamental rights of the detainees. Full stop. During the pendency of these writ petitions, the state government of Assam has constructed a detention center at Matia in the district of Gwalpara, having as many as 11 towers. Full stop. The declared foreigners, as mentioned herein above, have since been shifted to the Matia Detention Center, and they are presently being housed in as many as 3 such towers with adequate facilities for declared foreigners. Full stop. However, declared foreigners, to that extent, the relief prayed for in this batch of writ petitions do not survive for consideration of this court at this stage. However, Mr. Gautam has argued that although the detainees are now housed in the Matia Detention Center, yet a part of the detention center, including as many as 8 towers, have now been designated for housing the regular under trial prisoners stroke convicts convicted of offences under the Prevention of Corruption Act.
Child management.
Huh?
Child management. PCA.
Because of child marriage, a
Child-
lot of persons were arrested. That is why at that point
Child
of time,
Marriage Act,
now it is not there.
POCSO Act 2012, etc. And therefore, the state government has evidently converted the detention centers once again into regular jails, thus acting in violation of Packet Supra. First up. Responding to the above arguments, Mr. Nath has argued that the detention center is still meant exclusively for the declared foreign nationals. It's still meant for housing the declared foreign nationals exclusively until their deportation in accordance with law. However, since there were sufficient empty towers available, and in view of the upsurge of cases pertaining to child marriage stroke POCSO Act, as a temporary measure, some of the towers were designated for housing the under trial prisoners. Full stop. Since it was a purely temporary measure, hence it cannot be said that the detention center has been converted once again into a regular jail. Full stop. Mr. Nath has further argued that since the purpose of filing the habeas corpus petitions have already been met, these matters be closed as no further relief to the petitioners can be granted in these petitions. We have considered the submissions made at the bar and have carefully gone through the materials available on record. It is not in dispute that the construction of the Matia Detention Center is complete and the declared foreigners who were the subject matters of these habeas corpus petitions are presently housed in the detention center, whereas some of the detainees had been released on bail during the COVID period. Full stop. The controversy at this stage is pertaining to housing of regular under trial prisoners to convicts pertaining to child marriage stroke POXO Act offences in as many as 8 towers designated for the purpose in the Matia Detention Center. Full stop. After hearing the submissions of the parties, we are of the view that whether such a recourse adopted by the state government is permissible in law or not would definitely be a relevant issue to be adjudicated by this court as and when the same is brought, as and when the occasion arises. However, this, in the opinion of this court, gives rise to a new cause of action, and therefore, in the absence of proper pleadings and particulars pertaining to the manner in which the vacant space in the 8 towers is being presently utilized by the state, indicating the prejudice, if any, that has been caused to the declared foreigners, bracket detainees, it would not be permissible for the court to go deeper into the matter. First of all, as such, by granting liberty to the petitioners or any other aggrieved parties to raise the aforesaid issue by filing appropriate petition questioning the usage of the vacant area of Matia Detention Center and matters ancillary thereto. We close these habeas corpus petitions as infractions.
Grateful.
Item 6 to 15.
এমনি চলাই রাখেছে
Yes, 6 to 15.
Item 6 to 15.
Anybody appearing?
Manish is 7 or it's-
May it please your lordships. My lord, I am appearing in WPC number 2729 of 2019, item number
Item number 6.
6. This pertains to craft teachers. My lord, basically, what
Mr.
we are,
Chaudhary, before going into the meat of the matter, could you just give us the landscape of these litigations?
the landscape is something like this. Under the scheme of 2011 Act, which stands repealed, there is a deeming provision Now the question is whether that accrued deeming right.
But nobody from the state is there. Last time, it seems the state had considered.
Oh.
Original 2011 Act, there was a concession.
Oh, yes, yes, it has been struck down by the honorable court
No, but on a concession by the state.
on a concession by the state.
If they are giving a concession this time also, then
Yes,
why should we?
court need not decide. Because that right cannot be taken. মইতো এইটো কোৰ্টত গৈছো সেইটো দৌৰ মাৰি গৈছো
All right, yes.
Yes. So basically, as far as these craft teachers are concerned, our basic point is in terms of section 2H read with section 4 of the Repealed Act, there is a deeming provision that we would be, our services would be provincialized. In fact, persons identically placed like the petitioners were provincialized. Our cases were considered by the district level committee. It was forwarded to state level committee. Identically placed persons services provincialized. We were supposed to be done in the second phase. It was at that stage that this litigation came up where state made a concession. There was a judgment, there's a repealing clause, then there was a review, so many things. Now, our simple case in this case is there is a deeming provision. In terms of the deeming provision, we have acquired a right. The only issue is by way of 2017 Act, can you take away them? Because that is a right which is accrued. There's something which was not so happened in the future date. It had already happened. A legal fiction was created. That is the case. If you also would kindly have the 2011 Act in this book, 647. First, come to the definition clause, section 2H.
Yes.
Employees means and includes all serving employees, both teaching and non-teaching of venture educational institution, who have been appointed by the concerned venture educational institution before 1st day of January 2011, whose services are being or would be provincialized under this Act. Now, please come to section 4.
Yes.
The services of the employees of all eligible venture educational institutions under section 3 shall be deemed to have been provincialized on the date of coming into force of this Act, and they shall become employees of the state government with effect from that date, provided such institutions have completed at least 7 years of imparting education from the date of affiliation, recognition, concurrence or permission as the case may be on the date of coming into force of this Act. If we fulfill that requirement which is envisaged by the proviso part, then our services are deemed to have been regularized. How can this right be taken away? This is a crystallized right. That's the short point involved in most of the cases. Book is this one. Is hello. Dustbin लग गया. That apart, now if your lordship would kindly come to the 2017 Act in this new book, same book, page 99. Please come to section 2, Roman 5. Maybe. Sorry, section 4.2, Roman 4. Section 4 at page 114. At page 114. Subject to the fulfillment of all other provisions of this act, the services of teachers and or tutors of all venture educational institution eligible under section 3 shall be deemed to have been provincialized on the date of publication of this provincialization order by notification in the official gazette, and they shall become employees of the state government with effect from such date. Now please come to Roman 4. In case of teachers or tutors of the schools for special subject like Sanskrit, Arabic, where craft teacher, music teacher and other classical teacher, the number of students appeared in the concerned final examination like HSLC and HS2, the HS that is 10 plus 2 conducted by SEBA or Assam State Higher Secondary Council, as the case may be, shall not be less than 10 students in each class per year during the last 3 years. So this is a new requirement which has been envisaged. So by incorporating this new requirement, our vested right is sought to be taken in.
You represent craft teachers.
Yes. Then please come to section 6. The services of teachers in a venture educational institution from primary level up to the degree level shall be considered for provincialization in the post of teacher or relevant teaching faculty in appropriate nomenclature as the case may be, subject to fulfillment of eligibility criteria relating to educational and professional qualification as laid down under the following acts. So these are the different acts under which the applicant or the teachers working in the venture education institution must fulfill. 2. Services of teaching employee in a venture education institution shall be considered for provincialization as teachers only if they have the requisite academic and professional qualification prescribed under the relevant acts and the rules or regulation as mentioned in subsection 1 of this section, which are applicable for the time being in force. Otherwise, their services shall be provincialized as tutor. Then 7, educational and professional qualification of tutors. So anyway, the tutor aspect is not relevant in this case. Some other cases, it will be relevant. Then please come to section 24. The Assam Venture Educational Institution Provincialization of Services Act 2011 as amended by the Assam Act of 2012 and the Act of 2013.
You are reading which section?
Section 24, the repealing and savings provision. At page 126.
Yes.
The Assam Venture Educational Institution Provincialization of Services Act 2011 as amended by the Assam Venture Educational Institution Provincialization of Services Amendment Act 2012 and the Assam Venture Educational Institution Provincialization of Services Amendment Act 2013, which have been struck down by the Honorable Guwahati High Court by order dated 23/9/16 in WPC number so and so, and all rules, orders, notifications issued thereunder shall stand repealed. However, all teachers whose services were provincialized prior to 23/9/2016 shall continue and their cases shall be reviewed as per eligibility norms set forth for provincialization under this act. Now, these are the persons whom we say they're identically placed, and in the first page, these people are all with similar qualification, their services were provincialized. Now, this so-called review has never taken place, in spite of this statutory mandate. I think about more than 40,000 teachers were provincialized. Now, in this craft teacher's case, our simple case is that now there's, of course, there is one more aspect Lordship will have to examine. Now, when we talk of repealing and savings clause, now what Supreme Court says is more than whether there is a savings clause or not, repealing or savings clause or not, what is important to notice is whether by the impugned act there is an intention to deny the benefit which accrued under the old act. If it is not there, then even if there is no repealing or savings clause by virtue of section 6 of the General Clauses Act, it will be presumed that earlier rights are saved. That's the law. Now, in the facts of the present case, when your Lordship notices, section 2H read with section 4 of the 2011 Act creates a deeming provision. And as we all know, whenever a statute creates a deeming provision, it is the duty of the court to give effect to such a deeming provision. So we already stood regularized on the date when 2011 Act came into force. So that's a right which we have acquired. Now, the law, so the Supreme Court says, when it comes to rights which have been acquired, that you cannot take away by a subsequent amendment. I can appreciate, my lord, if a right is to accrue at a future date, that can be taken away. But here a right has accrued. I can place one or two judgments on this point. So that way, major part of these litigations will be covered by this. In fact, Lordships had the occasion to, of course, that matter we withdrew, but then this point was gone into by this Honorable Court.
Is that order there with you?
No, because that judgment did not. Oh, it was ordered to full name, right?
No, there is that order was passed by.
Yes. If your Lordships would kindly have this judgment. I think my junior has given the book list. Yes. Please have 1987 3 SCC 622. Asane judgment book. 1987 3 SCC 622.
No, Mr. Chaudhary, there is another order. Your case was those town and country plan.
Now, because my lord, that did not
that-
ultimately there was no judgment
There was
because
that was
we withdrew the pace.
But there is another matter
Ah.
where I remember I had authored the order.
Uh-huh.
Same point was involved.
Yes, there was one.
Perhaps it was your matter only.
I appeared. Please come to para 18, my lord. Para 18 at page 638. It has been held by this court in E.P. Royappa and Maneka Gandhi that there should not be arbitrariness in state action, and the state action must ensure fairness and equality of treatment. It is open to judicial review whether any rule or provision of any act has violated the principles of equality and non-arbitrariness and thereby invaded the rights of citizens guaranteed under Article 14 and 16 of the Constitution. As has been stated herein before, the assistant engineers who have already become members of service on being appointed substantively against temporary post have already acquired the benefit of 1936 rules for having their seniority computed from the date of their becoming member of the service in 69 and 71. 69 and 71 amended rule takes away this right of these temporary assistant engineers by expressly providing that those assistant engineers who were selected and appointed in permanent vacancies again 50% quota provided by Rule 6 of the amended rule will only be considered for the purpose of computation of seniority from the date of their appointment against permanent vacancies. Therefore, the temporary assistant engineers are not only deprived of the right that accrued to them in the matter of determination of their seniority, but they're driven to a very peculiar position in as much as they are to wait until they are selected and appointed against permanent vacancies in the quota set up for this purpose by this amended rules. So in these facts, my lord, their already seniority was computed. By virtue of the amendment, what was said, those who are appointed against permanent posts, they alone will get seniority. Supreme Court says, sorry. Once the right is accrued, you cannot take away that right. Then, my lord, the other decision is Union of India versus Tushar Ranjan Mohanty, 1994, 5 SCC 450. Oh, I do go to that. When I come to question. My lord, oh yes. Now, sorry, my lord, I ought to have placed one passage, my highlight Korea show. Please come to page 639. Does the 69 amendments?
Yes.
Page 639, towards the about 15 lines from bottom of para 18, the sentence starting with thus 1969 and 71 amendments. At page 639, thus 1969 and 70, has Lordship's got it? Yes. Thus 1969 and 71 amendments in effect take away from the officers appointed to the temporary post in the cadre through Public Service Commission, that is after selection by Public Service Commission, the substantive character of their appointment. These amendments are not only disadvantageous to future recruits against temporary vacancies, but they're made applicable retrospectively from 1st of March 1962, even to existing officers recruited against temporary vacancies through Public Service Commission. As has been stated herein before, that the government has power to make a retrospective amendment to the rules. But if rule purports to take away the vested right and are arbitrary and not reasonable, then such retrospective amendments are subject to judicial scrutiny if they have infringed Article 14 and 16. So this is the, my lord, legal dictum. So for one, you cannot take away vested right. And secondly, it must not result in a situation where Article 14 and 16 would be violated.
So is there some clarification in the review petition order on this? Whether it will take
No,
prospective
no,
effect,
no,
retrospective, nothing.
Substantively, nothing, my lord. In fact, my lord, to be very candid, whether on concession a law can be made nullified, that is also a question. It needs to be gone into, my lord. Because the scope of interfering with the legislations are very limited. Violation of Article 14, basically Part 3 of the Constitution. Now, of course, 2-3 new grounds have emerged that manifest arbitrariness. I'll place that judgment. In fact, there are quite a few judgments, Nafte's, and then Shreya Singhal and all these cases, where this new proposition has come up. Now, please have this Tushar Mohanty, para 12 and 13, 1994, 5 SCC 450. Please come to page 456, para 12. In page 456, para 12, last two lines are towards the bottom. In T.R. Kapoor versus State of Haryana, three petitioners, T.R. Kapoor, Mahinder Singh, and V.D. Grover, who were diploma holders were working as subdivisional officer on regular basis under the unamended Rule 6B of the Punjab Service of Engineers Class 1 Public Work Department Irrigation Branch Rule 1964. They were eligible for promotion as executive engineers in Class 1 of this service, despite the fact they did not possess a degree in engineering. By the notification dated 22/6/84, Rule 6B was amended and it was provided that degree in engineering was an essential qualification for promotion of assistant engineers to Class 1 service, and thereby the petitioners were rendered ineligible for promotion to the post of executive in Class 1 of the service. The amendment was challenged in this court by way of a petition under Article 32 of the Constitution of India. This court came to the conclusion that retrospective effect given to the amendment was violative of Article 14 and 16 of the Constitution of India on the following reasoning. It is well settled that power to frame rules to regulate conditions of service under proviso to Article 309 of the Constitution carries with it power to amend or alter rules with retrospective effect. Now the case laws are cited. It is equally well settled that any rule which affects the right of a person to be considered for promotion is a condition of service, although mere chances of promotion may not be. It may further be stated that an authority competent to lay down qualification for promotion is also competent to change the qualification. The rules defining qualifications and suitability for promotion are condition of service and they can be changed retrospectively. Now, this is important. This rule is, however, subject to the well-recognized principle that benefits accrued under the existing rules cannot be taken away by amendment with retrospective effect. That is to say, there is no power to make such a rule under proviso to Article 309, which affects or impairs vested right.
Mr. Chaudhary, if
Yes.
I remember correctly,
Yes.
T.R. Kapoor, they were given promotion,
Huh.
but after the rules were changed,
Yes,
the promotion was sought to be erased.
correct.
It is in
Correct.
that context.
Yes.
Is that
Now, my lord, I think everything will be clear
so? How
once
are
I
you drawing
place
a-
J.S. Yadav's case.
How are you drawing a parallel of T.R. Kapoor with the facts of this case?
Not necessarily, but there is a deeming fiction. There is a deeming provision which stood provincialized. Only thing is, it was a matter of time. Our services stood provincialized because that's the mandate of the act. So now that right cannot be taken away. It's not that I think I was supposed to earn a
So you
provision
mean
under
to
the
say-
old rule.
You mean to say
Yes,
that in view of these provisions in the rules,
yes.
going forward at some stage, your client services will be in provision.
In fact, in the first such exercise, persons identically placed like us, their services were provincialized. And ours were also cases were forwarded by the district level committee and state level committee. All that was left to us. In the second phase, it would be done. It was at that stage all these intervening developments took place, including that declaration of that law, etc., etc. So now
Declaration
eventually
of
we are
law?
having a new law.
Declaration of which law?
That
Acha,
the 2011 Act. Now, J.S. Yadav will set at rest all the controversy. 2011 6 SCC 570. Now, it explains what is a vested right, etc., etc. I placed the judgment the other day, Miller, before the division bench, this judgment. 2011 6 SCC 570. Now, please come to para 22, my lords. 22 to para 30. Thus, vested right is a right Thus, vested right is a right independent of any contingency, Such a right can arise from a contract, statute, or by operation of law. A vested right can be taken away only if the law specifically or by necessary implication provide for such a course. The appellant had been appointed under the provisions of the 1993 Act, which did not require 7 years experience as a district judge. In the instant case, 2006 Amendment Act came into force on 23/11/2006. The state of UP did not take any steps for discontinuation of the appellant up to May 2008 on the ground that he did not possess the eligibility as per 2006 amendment. The legislature is competent to unilaterally alter the service condition of employee, and that can be done with retrospective effect also. But the intention of the legislature to apply the amended provision with retrospective effect must be evident from the Amendment Act itself, expressly or by necessary implication. The aforesaid power of the legislature is qualified further that such a unilateral alteration of service condition should be in conformity with legal and constitutional provision. This is the Katz-Miller. The Union of India, in Union of India and Tushar Ranjan Mohanty, this court declared the amendment with retrospective effect as ultra-virus as it takes away the vested right of the petitioners therein, and thus was unreasonable, arbitrary, and violative of Article 14 and 16. While deciding the said case, this court placed heavy reliance on the judgment in P.D. Agarwal versus State of UP, wherein this court is held as under. The government has power to make retrospective amendment to the rules, but if the rules purport to take away the vested right and are arbitrary and not reasonable, then such retrospective amendment are subject to judicial scrutiny if they have infringed Article 14 and 16. In the instant case, 2006 Amendment Act is not under challenge. However, the issue agitated by the appellant has been that the legislature never intended to apply the amended provision with retrospective effect, and therefore appellant could not be discontinued from the post. His rights stood protected by provisions of Section 6 of 1897 Act, General Clausing. The issue of applicability of the provision has been considered by this court in so and so, wherein it has been held that rights accrued under Act ordinance, which stood repeal, would continue to exist unless it has specifically or by necessary implication taken away the repealing act, taken away by the repealing act. So, my lord, the right continues. Then please come to para 29. A constitution bench of this court in Railway Board versus C.R. Rangadhamaya dealt with the case where pension admissible under the rules in force at the time of retirement was reduced with retrospective effect. This court held such action to be unreasonable and arbitrary, being violative of Article 14 and 16 of the Constitution. This court observed as under. It can therefore be said that a rule which operates in futuro so as to govern future rights of those already in service cannot be assailed on the ground of retroactivity as being violative of Article 14 and 16. So if a right is to accrue at a future date, that can be changed. But a rule which seeks to reverse from an anterior date a benefit which has been granted or availed, as for example, promotion, pay scale, can be assailed as being violative of Article 14 and 16 of the Constitution to the extent it operates retrospectively. In many of these decisions, the expression vested right or accrued right have been used while striking down the imprudent provision which had been given retrospective operation so as to have an adverse effect in the matters of promotion, seniority. Now this is substantive appointment, etc. of the employees. The said expression have been used in the context of a right flowing under the relevant rule, which was sought to be altered with effect from an anterior date and thereby taking away the benefits available under the rules in force at that time. It has been held that such an amendment having retrospective operation has the effect of taking away benefit already available to the employee under the existing rule is arbitrary, discriminatory, and validity of the rights protected and guaranteed under Article 14 and 16. Thus, from the above, it is evident that accrued rights cannot be taken away by repealing the statutory provision arbitrarily. More so, the repealing law must provide for taking away such right expressly or by necessary implication. There is no specific words in the 2006 Amendment Act to suggest its retrospective applicability. Rather, the positive provisions of Section 1 suggest to the contrary as it reads. Now, if your Lordship kindly comes to the last two sentences of this para 2, thus, in view of the above, we do not have any hesitation to declare notification dated so and so is patently illegal. My Lord, my humble understanding from this, especially this Constitution Bench decision in Railway Board's cases, if a right has already accrued, then that right cannot be taken away by giving any retrospective effect. But if a right is to accrue in future, that some right will accrue in future date, that can be taken away. Now, for example, in this case, my Lord, we were deemed to be, our services were deemed to have been provincialized by operation of law. Now, where is the intention in the new act that the said right is sought to be taken away? There is no express provision. So therefore, this 2017 Act, especially Section 4(6), this this cannot withstand judicial scrutiny. Is end of the day is violative of Article 14 and 16. Now, here in this case, now the school in which we are working, there must be at least 10 students. That is the requirement. In case of teachers, now RT rules have been made applicable. That means
Mr.
you must
Chaudhary,
have some professional.
Can we just go back to the original provisions, 2H
Yes.
and 4?
Yes,
Once again, to see what is the right of your client. which is-
yes, fine. Then please come to 2D, it's 647. First come to section 2H.
Yes.
Employees means and includes all serving employees, both teaching and non-teaching, of venture educational institution who have been appointed by the concerned venture educational institution before 1st day of January 2011, whose services are being or would be provincialized under the Act.
So according to you, 2H is that provision which gives rise to a right of your clients.
Read with section 4 of the Repealed Act.
Yes.
Employees to be government servant. Services of employees. Now we refer to the definition of employee because section 4 refers to employees. Services of the employees of all eligible venture educational institutions under section C shall be deemed to have been provincialized on the date of coming into force of this act, and they shall become employees of the state government with effect from that date, provided such institutions have completed 7 years of imparting education from the date of affiliation, recognition, concurrence or permission as the case may be on the date of coming into force. So when in 2H, it refers to employees whose services are being provincialized, includes those whose services were provincialized in the first phase. Are to be provincialized is the category where we fall. In the second phase, it was to be done because the prior requirement, that is approval by the district level committee, state level committee, these are all over.
So two things, just for clarification. You are representing those craft teachers who were serving in eligible venture educational institutions. And they had completed more than 10 years of service.
They have completed between 12 to 26 years. I've made that statement in para 2 of the writ petition. 12 to 26 years. Where do we go now? A person who has served for 26 years, where he will go? End of the day, my lord, state is a welfare state. It's not a state, my lord, which is very rich. We are still, my lord, crawling. The other day, my lord, I have read one news in Times of India, where of course these are allegations. I think for setting up that unit in the state of Gujarat, government is paying 3.25 crore to that US company for giving one job here in India. And we do not know how much we will be paying for that Gujarat Jagi Road unit. Same. The benefit is that US company is getting as 3.25 crore for one employment given here.
All right, that's another matter, but
Yes.
so this is the sum and substance of the
Yes.
argument.
And I need not take your lordship's much time. This is in my humble submission, in this petition, this is the only point. In fact, in most of the petition, this is the point. If we succeed in this, we lordship need not go to other points. For example, in some cases, those who do not have the qualification, they have been appointed as a tutor. And in some cases, I have found they are insisting on NCTE requirement, whereas this same very notification says who are appointed prior to 23/8/2010, they need not have the qualification. Even those were also denied. In other two cases, I have come up with a written argument. I'll place it where I have given the facts, legal position, everything. Here in this case, I could not. Yesterday only I was going through it. If necessary, I'll give here also. So essentially, this is the point below. Now there is a crystallized right. Now can you take away that right? The law says you cannot.
So how this right is taken away by the new act?
Because now yes, how it is taken away, then come to new act, page number, it starts at 99. If your lordship would kindly come to page 115, Roman 4:4. Page 115 of the book.
We have made our own compilation.
Okay.
All right, you can refer to the
Subrule 4 of rule 4. Sorry, section 4, subsection. Sorry. Clause Roman 4 of section 4(2).
Yes.
In case of teachers or tutors of the schools for special subject like Sanskrit, Arabic, Hindi, craft teacher, music and other, the number of students appeared in the concerned final examination like HSLC and HS conducted by SEBA or HS, Assam State Higher Secondary Education Council, as the case may be, shall not be less than 10 students in each class per year during the last 3 years. So this is a new requirement. So because of this, we will not be, our cases will not be considered. You apply it prospectively, we have no issue. But to those who are working, in otherwise, in cases where the teachers of the venture educational institution, where they do not fulfill the requirement of section 6(1) of the new act, of the Repealed Act, there they have been appointed as tutor. Now there, my lord, what is the funny logic of tutor? Both are mandated to teach. So one you are giving regular scale, everything, and to other you are giving rupees 18,000 a month. These are not bonded laborers. These are all human beings. 18,000 a month. And the state's argument is we are at least giving this. If you don't do one, this is a different thing. Because on behalf of the state, that argument was made
So
once.
why was the review petition filed? Can you
Yes.
just go into that?
Yes, yes.
Why did the state seek review?
Possibly the state wanted to say that the implication of the judgment should operate prospectively. That review judgment lordships will get in our petition.
Several persons who were already provincialized, well, once the act was being set aside, the retrospectivity, if it was done with retrospectivity, everybody would lose jobs, but people were already, they had gone ahead in life till the
To
time,
85.
by the time when the act was set aside. Therefore, we filed a review, what happens to them. Therefore, this honorable court said that you will make provisions in the new act, if you make one, to deal with these persons who were already
What will be the
provincialized.
Provision made. Let us
Mala, that is.
That's
we-
section
we
24,
made
na?
27,
24,
that where we
yes.
could make a review of those already brought into the fold of the
Section
2011.
24.
Section 24, Lordship would find.
That
Page 126.
Repealing and savings clause.
মই খালি এই মানে ৰিভিউটো কিয় কৈছিলো সেইটো কৈ দিছো, বাকীখিনি নহয়। Lordship has 126, page 126, 24. The Assam Venture Educational Institutions Provincial Services Act 2011 as amended by the Assam Venture Education Institutions Act of 2012 and the Assam Venture Educational Institutions Act 2013, which have been struck down by the Honorable Guwahati High Court by order dated so and so, and all rules, orders, notifications issued thereunder shall stand repealed. Therefore, all the orders of provincialization also stood repealed if we stop there. However, all the teachers whose services were provincialized prior to 16 shall continue and their cases shall be reviewed as per the eligibility norms. Therefore, those who are required to be brought in as teachers
Right,
would
so-
be as teachers,
You
tutors to tutors.
address the court when your turn comes.
My lord.
But Mr. Chaudhary's basic argument is that you have protected the accrued rights of those teachers who were provincialized under the previous act.
My lord.
By stretching the same principle, the teachers who were deemed to have been provincialized under section 2H read with section 4 of the old act.
My lord.
The principle would extend to them also, with the only difference that the date of notifications have been deferred under the act, but they were deemed to have been provincialized for all practical purposes. So there being a deeming clause, it creates a vested right. And therefore, he might not have argued that in so many words. Probably what he's arguing is that this is a fit case for reading down the provision of section 4(1) subsection Roman 4. As this, as we could understand, subject to what my word, that is whether it is struck down or not is another matter. But at least his argument, is that correct, Mr.
Yes,
Chaudhary?
absolutely.
Is to read down the provision to interpret that all vested right accrued would also include the rights of those
Who were yet to be
deemed to
provincialized.
have been provincialized.
That's why I said, if we apply it prospectively, we have no problem. That's why I said that.
Ought to have been also taken care of by the act.
That part we can address. That part we have done our assessment. We'll address it when the time.
That's
will
the
come.
point. You please.
But there are
address.
judgments of this court which will be depending.
Yes. Well, as far as review is
Mr.
concerned.
Chaudhary, is that your?
Yes,
argument?
yes, absolutely, Milord. Absolutely.
Then we'll hear what they have to say.
Yes, yes. Then I can go on to my other petitions, my lord, because more or less same. Only thing is, this is a club. More case kita kun kita asile asan. I think, my lord, এইটো number কিমান হ'ব? এইটো ঠগিৰাম. If your lordship should kindly have item number 49. এখন দিবা না? শুনিবা নেকি?
No, your other petition means,
Item number 49.
Mr. Chaudhary, we would like to first conclude with
Okay.
6 to 15,
Okay.
because otherwise it creates a
Hey,
little.
Otherwise you'll get confusion.
Do you have any other matter within 6 to 15?
No.
So we would like to finish.
Mil-
with
mila.
6 to.
Oh.
May it please your lordships,
Yes.
I am appearing in item number 7. That is writ petition 8148 of 2018. Noor Islam and 51 others was the state of Assam. Written submission India. Program.
Yes.
Now, lordship, I am representing 51 music teachers. These are music teachers. Now, if lordship will take up my 4-page note, because for the convenience of the court, we have actually summed up what is our case. Now, these are the petitioners are music teachers working. May I?
Yes, please.
The petitioners are music teachers working in different high schools, high madrasas across Assam. They have been appointed on various dates, years starting from 1994 till 1995 till about 2005. They are both eligible and qualified for their services to be provincialized as per the provisions of the Assam Education Provincialization of Services Act 2011. Second is important, the petitioners are neither dropped nor excess teachers as per the number of posts indicated for music teachers per school in the schedule appended to the Assam Education Provincialization of Services Act 2011. The petitioners are praying for issuance of an appropriate writ directing the state to issue a formal notification recognizing the provincialization of service of petitioners as music teachers with effect from 1/1/2013 as per the recommendations dated 6/6/2016 of the District Scrutiny Committee passed in terms of section 10, 3 and 4 of the Assam Education Act 2011. In addition, this writ petition also challenges the constitutional validity of section 2U, 4, 2, 4, 6, 7 and 24 of the Assam Act of 2017. Now, with respect to the arguments addressed by my learned senior brother, Mr. Chaudhary, I adopt it with respect to the validity. But my primary focus is, lordships, that we have, I will take lordships to those documents which we are relying, where we say that in fact our services actually stood provincialized, but for the formal notification under section 10(4). Those documents, we have put it on record. So therefore, my request before your lordship is either strike down section 24 as invalid, which creates a class within a class, or if lordship so wishes to save the constitutionality, read down section 24. The section that is standing between us and our provincialization. Now, lordship will kindly see these 4 documents that are relevant for my case. The first document, lordship, is at page 75. That is the document dated 28/7/2014.
Yes.
Lordship on it.
Yes, please.
This is lordship. Now, this is after the act was enacted the 2011 Act, of course, on the last occasion also I had indicated that there were no laid down qualifications for the purpose of provincializing music teachers. So there were several rounds of discussions, and in this 2004 notification, it says, whereas the representation from various teachers association and individuals in respect of music teachers have been received, and there was no prescribed qualification for the posts of music teachers in venture high schools and high schools at the time of their appointment. And whereas the posts of music teachers were filled up in provincialized higher secondary school and high school in the year 1994 from amongst candidates having minimum qualification of HSLC passed and BSARA BU music from any recognized university, board, college, etc. And whereas the government is satisfied that the qualification prescribed for the post of music teachers in the provincialized higher secondary and high schools during the period prior to 1/1/2006 may be taken into account for the same in the venture high secondary and high schools. Now, therefore, in exercise of powers conferred by Section 14 of the Assam Venture Educational Institutions Provincialization of Services Act 2011, the qualifications for the post of music teachers appointed in venture higher secondary and high school shall be HSLC passed and Bisharat B music from any recognized university, board, college, etc. This is followed by a subsequent notification, which is at page 76. The only difference is there they said this degree has to be from Bhatkandi. Now, having seen this, will Lordships kindly take up the additional affidavit that we have filed? It's on record. An additional affidavit has been
Yes.
filed. And kindly come to page 326 of that additional affidavit. Page 326 of the additional affidavit. Now, before I read this document, I would just like to point out that this is the order recommending our names for provincialization after the exercise contemplated under Section 10 of the 2011 Act was done. Dated Kahilepara 6 June 2016. Please mark the date. Subject, provincialization of service of music teacher. Reference government notification so and so. Sir, with reference to the subject cited above, I have the honor to state that a list of 204 numbers of music teachers prepared after proper scrutiny as per guideline mentioned in government notification under reference. It is clearly stated that these music teachers have been working as per appointment made by the respective school managing committee of venture educational institutions prior to 1/1/2006 and recommended also by the district committee concerned. These music teachers are now eligible for recommendation to get provincialization benefit. Further, another list incorporating 10 numbers of working music teacher, those are qualified from Guwahati University as B music is enclosed herewith. These music teachers are also eligible as per the Act. Government is therefore requested to look into the matter for line of action to be taken in this regard. Now, after this, Lordships will kindly have a look at two subsequent events that happened. Lordship will kindly come to the writ petition. Annexure. Writ petition concern. Please come to page 75 and 76. Sorry, Lordship, page 77. Page 77. This is a follow-up to the order I just read, Lordships. 22nd June 2016. Again, the Lordship mark the date, Lordships. Please mark the date. May I place it, Lordships?
Yes, please.
Reference letter number so-and-so dated 6/6/2016. That is what I read. Sir, with reference to the above, I am directed to request you to clarify whether the proposed 214 numbers of music teachers are required to be created as new posts or have already been created by the government. Thereafter, Lordship will see the next document, which is at page 78. Lordship will again mark the date. It is 24th of August 2016. This is from the Under Secretary. Sir, I am directed to refer to your letter cited above and request you to furnish the total financial implication and budget provision for creating the proposed 2014 post of music teachers for provincialization of service of music teacher. Now, having seen this, Lordships, it is more than evident that there was a clear intention by the government to provincialize it. In fact, our services actually stood provincialized. So therefore, if Lordships, I come back to my submissions, which I had submitted. I'm just limiting it to the fact that I'm praying for a mandamus now, appropriate writ, that at least the government be directed to give effect. It is by first submission, it is evident from letters dated 6/6/2016, 22/6/2016, and 24/8/2016 that the state was very clear in its intention to provincialize the services of the petitioners herein under the 2011 Act, and that the services of the petitioners indeed stood provincialized much before the Act was struck down. Hence, the state cannot be permitted to change their stand now. It may be further noted that the services of the petitioners as music teachers were provincialized within the cap, that is one post per school, as laid down in the schedule appended to the 2011 Act. Therefore, in the facts and circumstances of the case, an appropriate writ and or direction may be issued to the state to issue a formal notification recognizing the provincialization of the services of the petitioners as music teachers with effect from 1/1/2013. The proposition that a vested right cannot be taken away retrospectively in violation of Article 14 and 16 is fairly well settled. I will not read these two judgments, which has already been placed by my learned senior friend, Mr. Chaudhary. So I'm relying on the same. My second submission is the state cannot take advantage of its own lapse, delay in issuing the formal notification under Section 10(4), who are the writ petitioners prior to 23/9/2006. More so, when the petitioners were found eligible and recommended for provincialization by letter dated 6/6/2016, as also the follow-up action taken by the state, which is evident from the letters dated 22/6/2016 and 24/8/2016. The maxim, which is that no man can take advantage of his own wrong, is very well settled, Lordships. Now, coming to Section 24. Section 24 of the 2017 Act is unreasonable, unjust, unfair, and arbitrary. Hence, Section 24 is liable to be declared as invalid or be read down. There is absolutely no difference between the approximately 42,000 employees provincialized under the 2011 Act and the petitioners. They form a same class without any intelligible differentia separating them. The aforesaid classification is an artificial classification which does not bear any rational nexus with the object sought to be achieved. The concept of intelligible differentia is pivotal in a reasonable classification requiring the formation of groups with shared characteristics that distinguish them from other groups. The criteria cutoff date adopted by the state, that is 23/9/2016, to create a separate class of employees falls foul of all the below four preconditions that are necessary to make a valid and reasonable classification. Now, I will not go through all this because these are all laid down. I will just place two judgments in this regard, Lordships. These are settled law. Only one would be sufficient. Lordship will kindly take up 1989 2 SCC 145. I have copies for the court, Lordships. Because on all these four premises, that is intelligible differentia, rational nexus, legitimate purpose and fairness and arbitrariness, section 24 falls foul. Now, will Lordship kindly take up Deepak Sibbal, para 9 at page 151.
Para 9.
Para 9 at page 151. Deepak Sibbal. The citation is, I'm sorry, I should have read the citation. 1989 2 SCC 145. Justice Chaudhary, sir. It is now well settled that Article 14 forbids class legislation, but does not forbid reasonable classification. Whether a classification is permissible classification under Article 14 or not, two conditions must be satisfied, namely, that the classification must be founded on an intelligible differentia, which distinguishes persons or things that are grouped together from others left out of the group. Please pause for a moment, and I'm asking myself a question. What is the difference between me and those 42,000? Except for the intervening fact of the act being struck down. Except for the fact of the act being struck down, what is the intelligible difference between me and the 42,000? I don't see any, subject to what the state says. Number two, that the differentia must have a rational nexus to the object sought to be achieved by the statute in question.
So the expression struck down has not been used in the judgment, right? It says,
23/9/2016.
is the expression struck down there?
In section 24, yes.
No, in the judgment.
The judgment.
Judgment of the division bench. Or it only says we declare it unconstitutional, is it? Just asking for some other reason.
I'm sorry, I didn't get your
The
question.
judgment by which the 2011 Act was interfered with, the operative part, does it mention about striking down?
But it says invalid on concession,
It says declared unconstitutional.
unconstitutional. Would have the same, perhaps, effect, subject to Lordship.
Perhaps, or are you sure?
I'll have to. Very well, let me rephrase it. Whatever is following, except for the fact constitutionally invalid. That is the X.
Sentence used would be, when such substantial defects are perceived in a given context, the court can strike down only the offending provisions. However, when unconstitutionality is noticed in the major provisions starting from the preamble, striking down the offending portion would practically decapacitate the Act of 2011. In other words, the statute itself would become inoperable, although the ultra-vires declaration is limited to some segments of the Act. Therefore, we feel that a piecemeal exercise would not serve the purpose, but at the same time to suggest how a provincialization act should be reshaped would be intruding in the domain of the legislature. That is how it went, my lord.
Then
The intent was to, under these provisions, being convinced with the arguments of the petitioners, we declare the Assam Venture Education Institution Act is 2011 is constitutionally invalid, as the state has decided. Though the strike down word for the act was not used. It was held to be
You see, we are asking this question because at some point of time, we'll request the learned counsel also to shed some light on these aspects. Is it a case where the court has struck down the act and therefore the legislature has come up with a new act? Please try to understand the query. Or is it a case that the court felt that the law was not good, but left it to the legislature to repeal it by bringing it another law? Are you getting the point? It is one thing to say that we are striking down. So that's all. To do whatever is legally permissible. It is another thing to say that we also feel that this is not good law. That's all. Then the state goes back, enacts a new law with the saving and repeal provision, and it replaces the old act by a new act. Which of the two things has happened here is what at some
We'll
point
find.
of time we would like to, because it will have somewhere it will have some bearing on the approach of the court in the matter. Mr. Goswami, I hope you have.
Yes, sir, we have got the
Understood the
point. We have
point.
got the point.
There is a There is a thin line here.
Yes.
Maybe the other eminent counsels will like to know their view. We have come across judgments where the court has clean strike.
And leave it to the legislator, whatever they want to do.
We have come up with cases where the court has not struck down, but has expressed reservation, so the legislature on its own repealed the act. Which of the two has happened here, we are not very sure.
I will place
Would like
this.
to
Yes, yes.
little.
Now, we will definitely get back to on the lordship query. Now, would lordship please carry on, if I may just carry on with the judgment.
Yes.
Para 10.
Hmm.
लिखिल हुआ query. लिखिल हुआ. By the impugned rule, a classification has been made for the purpose of admission to the evening classes. The question is whether the classification is a reasonable classification within the meaning of Article 14 of the Constitution. In order to consider the question as to the reasonableness of the classification, it is necessary to take into account the objective for such classification. It has been averred in the written statement of Dr. Balram Kumar Gupta, Chairman, Department of Law, Punjab University, Respond number 2, filed in the High Court, that the object of starting evening classes was to provide education to bona fide employees who could not attend the morning classes on account of their employment. This was the objective. The object, therefore, was to accommodate bona fide employees in the evening classes as they were unable to attend the morning classes on account of their employment. Admission to evening classes is not yet open to the employees in general, including private sector employees, but is restricted to regular employees of government, semi-government institutions, etc., as mentioned in the impugned rule. In other words, the employees of government, semi-government institutions, etc., have been grouped together as a class to the exclusion of employees of the private establishments. Now, let us see how the court has answered this query, Lordships. Now, Lordship will come to Lordship, para 14. At page 153. It is difficult to accept the contention that the government employees or the employees of semi-government and other institutions, as mentioned in the impugned rule, stand on a different footing from the employees of private concerns insofar as the question of admission to evening classes is concerned. It is true that the service conditions of the employees of government / semi-government institutions, etc., are different, and they may have greater security of service, but that hardly matters for the purpose of admission in the evening classes. The test is whether the employees of private establishments are equally in a disadvantageous position like the employees of government, semi-government institutions, etc., in attending morning classes. There can be no doubt, and it is not disputed, that both of them stand on an equal footing, and there is no difference between these two classes of employees in that regard. To exclude the employees of private establishments will not therefore satisfy the test of intelligible differentia that distinguishes the employees of government, semi-government institutions, etc., grouped together from those employees of private establishments. Now, the last 4 lines is important. It is true that the classification need not be made with mathematical precision, but if there is little or no difference between the persons or things which have been grouped together and those left out of the group, in that case, the classification cannot be said to be a reasonable one. This is what I'm relying on. This is the law as laid down. Now, reading further, Lordships, para 20, at page 156. In considering the reasonableness of classification from the point of view of Article 14 of the Constitution, the court has also to consider the objective for such classification. If the objective be illogical, unfair, and unjust, necessarily the classification will have to be held as unreasonable. And it is our respectful submission that the classification that is sought in Article 24 is all three. Sorry, Lordship, Section 24 is all three. In the instant case, The foregoing discussion reveals that the classification of the employees of government, semi-government institutions by the impugned rule for the purpose of admission in the evening class of 3-year LLB degree course to the exclusion of other employees is unreasonable and unjust, and it does not subserve any fair and logical objective. I leave it at that judgment. The other judgment that is in my note reiterates the same position of law, so I will not take lordships. I will not read through that. That is the celebrated judgment of Motor General Lordships. Copy to Dixon. I'm just handing over this copy of the judgment, but I'll not read it.
General traders.
Motor General Traders. Motor General Traders. Para 10. I'm reading but I will not place it. It reiterates the same position, and the legislation over time may become bad, but I'm not on that principle. I'm on the principle of Article 14 and 16. Now, what lordships, come back to my written submissions.
Which paras of motor general traders?
Para 10 lordships. Page 229, 229, 230. So,
Justice Venkataramaya.
yes, sir. Now, lordships, so my submission before your lordships is,
Yes.
in addition to what Mr. Chaudhary has placed, if lordship will again kindly have a look at section 24 of the 2017 Act, which is at page 316 of my writ petition. 316. If you read it carefully, I would like to place it. Mr. Chaudhary has placed it, but let me read it the way I want. I
Yes.
think it should be read.
One minute.
Yes, Lordship. 316 of my writ petition.
Yes.
The Assam Venture Educational Institutions Provincialization of Services Act 2011, as amended by the Assam Venture Educational Provincialized Services Amendment Act 2012, and the Assam Venture Educational Institutions Provincialization of Services Amendment Act 2013, which have been struck down. Now, this is again, lordships, what is troubling a lot, which has been struck down by the Honorable Guwahati High Court, wide order dated 23/9/2016 in writ petition so and so, and all rules, orders, notifications issued thereunder stand repealed. Now the next sentence. However, all the teachers whose services were provincialized prior to 23/9/2016. Please read this as an exception. What is meant by however all the teachers whose services were provincialized prior to 23/9/2016? What is the meaning that we give to these words? Because it doesn't indicate the number. Does it indicate only those for whom that formal final 10-4 notification was issued? In my respectful submission, it will include also people who stand on a footing like us. Because I will take lordships to section 10 of the 2011 Act. After that, nothing remains to be done. After the section 10 exercise is done, nothing else remains to be done except for formal notification. So this expression, however, all teachers whose services were provincialized prior to 23/9/2016, in my respectful submission, will also include the 51 music teachers and not what they are restricting. Shall continue and the services shall be reviewed as per eligibility norms set forth for the provincialization under this Act. So this is our submission.
So therefore, you want a declaration, not reading down at 24.
In case they come up with a stand that it is only those 42,000.
So that's all right, but that is your response. But you said
I
you are asking for reading down 24. You want a declaration.
want a mandamus.
That's right. So not reading down.
That's an alternative submission. If Lordship issues a mandamus, I am happy with the relief that I get. But if they come, because I would ideally say that this provision is invalid because it restricts it to only to 42,000. So that's an alternative submission that I'm reading down.
What is your main submission, main relief here? You want a mandamus, that a 10-4 notification should be issued. For the petitioners.
For the petitioners in respect, because we have that 6/6/2016 followed by 2 subsequent government letters, which expresses the clear intention of the government to provincialize. In fact, our services actually stood provincialized, but for the intervening issue. Now, Lordships, I will just now, Lordships,
Yes.
just expanding on besides the fact of these 3 communications that I have placed before your Lordships, I will also briefly touch on the deeming argument that my learned senior friend has made.
That is the 2H of the old act, is it?
Now, Lordship will kindly come to first section 4
Old act.
of the old act, page 53. Page 53.
Mhm. Section 4. Four one, yes, dimming.
Page 53. Employees to be government servant. The services of all employees of all eligible venture education institutions under section 3 and who have already completed 10 years of service in such education institutions without any break from the date of affiliation, recognition, concurrence, or permission, as the case may be, of the concerned institutions as on date of coming into force of this act, shall be deemed to have been provincialized, and they shall become employees of the state with effect from that date. Now, kindly read this with section 2H, definition clause.
Yes.
Employee means and includes all serving employees, both teaching and non-teaching, of the venture education institutions who have been appointed by the concerned venture education institutions before the first day of January 2011 and whose services are being or would be provincialized under this act.
That's right. So those persons who were not eligible to be provincialized or were not provincialized in due course,
Yes.
they are not employees under the 2011 Act. They would not be included in the definition of employees. Is that-
No, when they are using my reading of this, whose services are being or would be, would mean RB is we and would be, but who would secure this qualification and eligibility over the period of time would come with the expression. So we are, that we are being deemed.
All right.
Am I clear, Lordship?
We'll continue after lunch.
Very good.
You are appearing only in this matter. Any other case?
No. So 51 music teachers, Lordships.
And who are the other councils in this batch? 6 to 15?
Lord, I am in item number 8, my lord. 8, 10, 12, 13, 14, and
No,
15.
Mr. Goswami is there in item 8.
I'm in 7.
7.
My lord. And my series is also, my lord, relating to music teacher.
So you will play the same music or?
No, my lord, I am also with the same music played by my respected senior friends, my lord. Only, my lord, one judgment of
To the previous order. I've just found out. Would lordships take up this repetition? My repetition.
Yes,
Please, lordship, first come to page 261 of the
61,
261
yes.
of the division bench order. In fact, the statement was made by the state. Para 31,
Yes,
para 31, just the last 4 lines. Therefore, Mr. Saikia. Therefore, Mr. Saikia submits that the government itself has taken a decision to revisit the Provincialization Act to either repeal it or make comprehensive amendments to make it conform to the constitutional requirements and meet the objective of the government. Thereafter, lordships, will come to page 267. This is extracting the additional affidavit of the state. The DB was extracting the state's affidavit. Page 267. Discussion and conclusion.
yes.
Last line. When the arguments of the petitioner are analyzed, it is clear that the Provincialization Act has many legal failings. As it is not only discriminatory, but is also repugnant to many aspects of the RTE and other central acts. Noticing the merit on the points raised by the petitioners, the government in fact has considered about the defects in the State Act. The Education Commissioner in his affidavit averred that the state has decided to bring in a fresh legislation to streamline the process of provincialization by addressing the deficiencies in the present act. In such circumstances, the court can either strike down the offending legislation or target certain portions of the Provincialization Act to make the state legislation conform to the constitutional and legal requirements. And then
Yes,
lordship will kindly come to page 270. Para 39.
yes.
Therefore, we feel that a piecemeal exercise will not serve the purpose. But at the same time, to suggest how the Provincialization Act should be reshaped would be intruding into the domain of the legislature. Moreover, amendment exercise might have to be proceeded by a consultative process with all the stakeholders, and this is surely the responsibility of the state. That apart, it is certainly difficult to separate the bad from the good portion of the Provincialization Act. Under these compulsions, being convinced with the arguments of the petitioners, we declare that the Assam Venture Educational Institution Provincialization of Services Act 2011 is constitutionally invalid. As the state has decided to bring in a fresh legislation considering the likely time needed for the process, we direct the state to do that exercise as committed in the additional affidavit expeditiously and preferably in the next 6 months. It is ordered accordingly.
So the act is constitutionally invalid.
Yes, lordships. In fact, if lordships subject to correction, even if the court would to have used the expression being struck down, it would also have to be struck down as constitutionally invalid.
So therefore, the court has struck down the act.
And then lordships will kindly come to what he says in the review, because that is also interesting. We have to read both. Please come to page.
Let him finish.
Page 291, the struck down word is used.
That is the review.
Page,
No, that is 291 review. I'm coming to the review.
page number.
Page 273, the first paragraph. What prompted the state to file a review?
Yes.
Para 1. This application filed by the state to review, modify the common judgment and order dated 23/9/2016 in WPC 5825 of 2012 and other cases to the extent that the services of the already provincialized employees of educational institution Assam will not be impacted by the court's verdict. So they essentially wanted it to operate prospectively. Now please see what finally the court held at para 19, page 291.
Page 291.
Yes, lordships. Para 19. In the above circumstances,
Yes.
we are. In fact, before that, please read, may I also draw your lordship's attention to para 18. 18 and 19 may be read together because this is a very important fact. Page 290. The state in their application have stated that the group they are concerned with are those who have retired and are drawing pension. Another category who are now government employees and are receiving regular scale of pay, and people of same class who have moved on in their careers and in life. There are around 41,634 employees for whom the vested rights are already created under the 2011 enactment. Now, this is very interesting. But through retrospective application of our 23rd September 2016 judgment, they may not only lose their government jobs, but will also be disentitled to pension and salary. Moreover, the question of recovery of the already disbursed salary and pension may emerge. The harsh impact of retrospective application will be crippling for the already provincialized group, and their livelihood, in turn, life itself will be adversely impacted. As such, debilitating consequences will occur without any opportunity of or hearing to this category. Many families dependent on the earnings of the provincialized staff are enjoying a measure of social and economic security, and they all will be thrown to the streets without any fault on their part. In the above circumstances, we are of the considered view that the right of the employees who have been benefited under the struck down statute can be taken care of by giving retrospective effect to the proposed legislation if the legislature so decides. Till then, it is ordered that the services of the provincialized category and their status as government employees shall not be disturbed, and they will continue to receive all the benefits which they are getting under the Provincialized Act 2011 since struck down by the judgment under review. With this observation, the direction the matter stands disposed of.
See, Mr. Goswami, the reason why this question was put, this question can turn out to be a double-edged sword, depending on who is. We also wanted to ask you that at that stage, your clients never sought a clarification that these observations should extend to them also, since they were in the process of provincialization was in the anvil. That kind of a clarification was not sought.
No, we expected the state to be, because the state was representing all those people. It was for the state to fairly submit. That is why we were saying that the action of the state to only restrict to 41,364 was not correct.
These 41,364 were already provincialized.
That is what they say. That is what they say. What is meant by already provincialized is another expression lordship will have to.
That is the reason we are asking.
What is meant by that expression? Already, if section 4.1 is to operate, if lordship has to give the complete effect to the deeming provision, then I would say everyone
Mr. Goswami, please listen to this query.
Yes.
And this litigation, though seemingly simple interpretation, but has got some treacherous tracks, if we might say. So listen to this. Once the act was declared as unconstitutional, the state comes before the court seeking a review, primarily expressing concern that this is going to wipe away the benefits accruing to 41,000 something number of employees whose services have already been provincialized. At that stage, the state even does not even take into account people who are in the footing of your client, who are likely to be in the process of being or have a right. They are not even in the ambit. What the state is saying is only those who have already got an order of provincialization. So the division bench passes an order declining to make any effective ruling on that, but merely by observing, as in para 19, that it will be open for the only thing is those who are already in service, their service will not be disturbed. Service means service as government servant. Obviously, those who have been provincialized.
Provincialized.
So there was a protective ring of the division bench in the review petition also, covering those whose services were already provincialized. But no such benefit was extended to the other categories of employees who were expecting to be provincialized, but not yet formally provincialized. They were not covered under this observation in para 19. Now, the question that comes up before the court is, assuming that we accept your argument, will it not add words to the order passed in the review court in para 19, which was not specifically given by the court earlier? Or will it not? It may be yes, it may be no. But when the state came up with this plea that protect the rights of people who already got the benefit under the original act, they did not consider your clients to be in that category. But whatever they considered, the court even did not say anything except saying that they will continue in service. Don't disturb them. And they will receive all the benefits. So can it be said that in a way that chapter has been frozen by para 19 of the judgment passed in review petition? If yes, why? If no, why not? If yes, what will be the consequence? If no, what will be the...
Lordships, if I have to respond immediately to your Lordship's query, that chapter could not have been frozen because that fact was not before the court. The list was not before the court. The list for people like us was not before the court. So the court never had occasion to decide on our rights. If the list was before the court and the court had given a definite finding with respect to our rights, perhaps then, Lordships, what is falling from my Lordships may perhaps be correct. But when the issue was not before the court.
No, the act, according to you, some rights have accrued to your clients under the act. That act has been struck down. Then these developments happened where the state did not recognize the interest of your clients insofar as the continuing beneficiaries under the act is concerned. Matter was brought to the court, the division bench, in exercise of review jurisdiction, has given some opinion, but that is kept confined only to those whose services are already provincialized. So now, if we are to accept your argument or the arguments of Mr. Chaudhary, then we may have to say that no, not only do not disturb the services of who are continuing, but that will also include those who are in the process of being regularized or provincialized. Effectively, that will be the ruling.
No, if Lordships were to reject our contention, then there must be a valid classification. What is that?
No, it's not a question of rejection, Mr. Goswami. Please understand it's a final issue here.
Whether you are adding to what the earlier division bench said, that it is the limit, the relief is limited only to this 41,000.
Will we be modifying the earlier division bench order in the review petition? That's the simple question.
Well,
and to that extent, will it raise a jurisdictional issue? Because you cannot be, or at least you cannot claim to be total strangers to these proceedings, because once an act is struck down, so let's say when it was not struck down, the matter was different. Once the act is struck down, if your clients had a vested right, a vested interest, then should they not have approached the court and sought a clarification that the way you have given protection to those who are already working, we are also entitled to similar protection.
So therefore, we have come. Therefore, we have come. Therefore, we are before your lordships. And in fact, that was the state's case that please don't take away the benefits without hearing them because no one was party there.
All right, Mr. Goswami, you think about it.
I'll think
I
about it.
put it to you.
Very well.
Think about it.
We'll think about it.
And this is not a very happy question to be asked. But
No, if it's
a
occurred to your
relevant
lordship's mind, it is our duty to respond.
It's a relevant question
Abs-
because state asks a question to the court that what happens to people who have already got the benefits? Please protect them. The court says no, but don't disturb their services. And this number is 41,000 something. You don't come in that number. So that was a stage. Obviously, your clients and many other petitioners ought to have sought a clarification. What happens in our case? We are in the pipeline. Our cases are also under consideration at this stage, that stage. Either a formal notification is awaited, etc., etc. That clarification is not sought from the review court. Then this litigation comes in where the provisions are under challenge. That you can. There's no question of maintainability here. You can challenge. You definitely can challenge. But the challenge will have to be examined on purely on the touchstone of Article 14 and 16. Nothing else. The moment you bring in the facts situation, this will be an integral part of the facts, which one cannot escape. That's the reason why we are mentioning this. If it is a purely legal issue, that whether these provisions on its own, standalone, can succeed, if examined on the touchstone of Article 14 and 16, then it's all right. Nothing more is required. But if you are drawing the background facts, that this is what has happened, that is what has happened, which you are entitled to. But then this is also going to be a background fact that the state asked this question, we remain silent. We never sought a clarification from the court. That will also be a part of that background facts, which the court cannot ignore because it is a matter of things, the materials are on record. That's what all we are trying to point out.
I will definitely respond to this query, lordships. Please give me some time.
Certainly,
Tomorrow,
certainly.
I'll definitely respond to this.
Certainly.
Now, if you look at it, where to look it up?
And Mr. Chaudhary is not here.
I'll communicate to it.
This is why in the morning this question was put. Because you want the act to be examined purely on a constitutional point of view, Article 14, 16. All right. But the moment you bring in the facts, which both of you will have to bring in, this is where we were, these were the processes, therefore this is our standing in. Then should you not have come and sought a clarification before the division bench? In the review?
Ideally, yes, but we expected the state to be fair. The state did not put the correct facts before the court. The state did not put the correct facts before the court.
Expectation from the state is at the risk of the expectant. We can't comment on that, but on a purely technical legal point.
Lordship, this is a writ court. Lordship will perhaps not be bound by technicalities of law. As a writ court, lordships, ultimately, lordships will have to see whether what is being done is fair. A writ court can never be bound by
No,
technicalities.
you have the option to independently argue on the constitutionality of these provisions. That
But-
these are bad. Please try to understand, Mr. Goswami.
We have understood
We
it.
are indicating that if you go into the facts, if you want to draw your rights from the facts, then this is also an integral part of the facts, which is
Which will have
checking
to
at
be
the
dealt
facts.
with, which will have
That's the
to be
only
dealt.
thing. It's neither an opinion in favor or against anyone. It is just pointing out a facet. We have.
A fact as it
we-
stands,
it
which
is
we must
proper to
have.
go before we form an appeal, form an opinion, but this is a relevant issue.
We will
If
definitely
it's
respond to
possible at
this.
some stage you respond.
We will definitely respond to it.
All right. Yes, please proceed.
Yes. Now, I was on the act, lordships, before we rose for lunch, lordships, the court rose for lunch.
Yes,
So we were on section 4.1.
correct.
Along with which so therefore, on that deeming argument, page 53, lordships, of
Yes.
my writ petition.
Yes. Yes, please.
So section 4.1 I read. Now the section 4.1 came to be amended twice. Once in 2012 and then in 2000. That is also relevant to see what was the mind of the legislature.
Yes.
Please come to the first amendment in 2012, which is at page 66.
Yes. Yes, please.
I'll just read the amendment section.
Yes.
The services of the employees of all eligible venture education institutions under section 3 shall be deemed to have been provincialized on the date of coming into force of this act, and they shall become employees of the state with effect from the date, provided such institutions have completed 10 years of imparting education from the date of affiliation.
Yeah, you're reading which section of amendment of 2000?
Section 4, page 66, Lordships.
Yes.
The services of the employees of all eligible venture educational institutions
Yes.
under section 3 shall be deemed to have been provincialized on the date of coming into force of this act, and they shall become employees of the state government with effect from that date, provided such institutions have completed at least 10 years of imparting education from the date of affiliation, recognition, concurrence, or permission, as the case may be, as on date of coming into force of this act. So the legislature was very clear, it incorporated 10 years, but that deeming provision as it stood in the 2012 Act also. Then comes the 2013 amendment, which is at page 76. Lordship may not turn the page. The only difference is 10 years came to 7 years. Is at page 76. The 10 years was reduced to 7 years. Besides it, everything remained as it is.
Right.
Now, having sections, now Lordships will kindly have a look at section 5 of the 2011 Act, because I'm just trying to,
Yes.
I'm not showing section 4 in isolation. Let us see the sections and the flow of the Act with respect to our argument of deeming. Section 5, Terms and Conditions of Service, page 54. 5.1. Subject to the provisions of this Act. Lordship is at page 54.
Just 1 minute. Yes.
Mala
Yes,
Justice
yes.
Chaudhary, page. Subject to the provisions of this Act and rules made thereunder, all rules, including service rules and rules of conduct and discipline, which are applicable to the state government servant of corresponding ranks, shall be applicable to all employees of educational institutions whose services have been or would be provincialized under this Act. Then Lordship will kindly come, so this expression whose services have been or would be is stretching that 4.1 expression. Then Lordship will come to section 6. Management of education institutions where services of employees are provincialized. With effect from date of publication of the notification under section 4 of section 10, the administration, management, and control of all provincialized education institutions coming within the purview of this Act shall vest in the state government. Now, I'm just pausing here for a moment, Lordships. The schools where my clients are working, in respect to all the schools, this notification has been issued. Except for the music teachers in those schools, everything, the employees have been provincialized. Lordship may take that as a matter of fact. Now, Lordship will then come to section 10. Now, these are section 10 of page 56. What is the exercise contemplated? Before our employees recommended.
Yes.
Section 10, 1, page 56.
Yes.
There shall be one district scrutiny committee in each district, separately for elementary, secondary, and higher education, to scrutinize service records and other related issues of the serving teachers and staff of venture education institutions pertaining to provincialization of their services. 2, the Deputy Commissioner of the district by an order shall constitute the scrutiny committee for the respective district under the preceding section. Then 3, important. The district committee shall first scrutinize and prepare a list of all venture education institutions within the district which are eligible in terms of the provisions of this act, and shall thereafter proceed to scrutinize and verify the service records of all the serving employees who are eligible or would become eligible for being considered for provincialization of the services. And 10.4 is, the district scrutiny committee shall forward the verified list of eligible teachers school-wise in accordance with the number of posts specified in the schedule appended to this act to the concerned director, who shall, after making such further scrutiny as may be required, shall forward the same to the concerned Department of State Government for consideration and for issuing notification in respect of the eligible institutions and employees eligible for getting their services provincialized. So this last part is all that remained in our.
Yeah, but there is another part which remains.
Yes,
There was a
Kaushik.
query whether the posts are already there or not,
Yes,
whether the posts were available.
yes, yes. That is what I'll come to the schedule now.
All right.
It's important that I'll show the schedule also. Now, please read the schedule along with the section, which is at page 60 of the petition.
Page 60 of.
60. In fact, the schedule starts at page 59.
Yes.
Section 4.2 and 10.4, see sections 4.2 and 10.4. And then
Yes, please.
maximum number of, Lordship will kindly mark it, maximum number of employees per education institution whose services shall be provincialized. This is the schedule. And I would like to, Lordships, to kindly come to page 60 bottom.
Yes.
I am at high school / high madrasa 2 classes. Bottom of the page, Lordships.
Yes.
And if Lordship will turn over the page, we'll see music teacher. Music teacher 1. Page 61, music teacher 1, where the teacher is in position since 1106 or before. And we still continue to work as music teachers in these schools. Now,
So
if
you are
Lord,
saying one post was available
in each school.
in each school.
Therefore, Lordship will kindly please come back to my additional affidavit once again. I'm sorry, I should have shown it at that point itself.
Yes.
And kindly please come back to that notification of 6/6/2016. Page 326.
Yes.
And please, Lordship will come to the list itself. If Lordship will see, Lordship may take it from me that all the petitioners are in this list. If Lordship will just see serial number 1, Buxa district, the name, he is petitioner number 19, and the school is also indicated. For each person, the school is indicated where they have to be provincialized, along with the post. So therefore, the schedule recognizes one person per school. And this is exactly, this whole scrutiny was done under section 10. And thereafter, this list was finally issued. Lordship may just mark it as serial number 1 is petitioner number 19, 2 is petition number 6. If Lordship, we can give that.
It's all right, listed here.
So therefore, having seen this and having seen the schedule, which clearly indicates that per school there is one teacher's post, and it is a matter of fact that provincialized post still remains vacant, and I'm still working in those schools.
So what has happened to those posts now?
They're still there.
Still there.
As per my instructions, they're still there. It is not that some other music teacher has been provincialized against those, no. Subject to correction by the state, but those are my instructions.
Mr. Majumdar, you have instructions on that?
But these posts were created after the persons who were found to be eligible to be provincialized after that, the posts are created. These are schools which were not government schools or provincialized schools. Existence of a post does not arise in government records. They were private schools.
So that
Let
means
us-
we are asking you at the moment, do you agree with this or you don't?
No, but there were no posts and there is no post. That is all.
Now, the post work, I have shown that document where the posts have been created. We have shown that the posts were created. So therefore, on this deeming provision,
Yes, just a minute, Mr. Gupta. What my learned brother is pointing it out, that in the schedule of the new act, is there a provision for a music teacher in every school?
yes,
It's there.
not in the schedule, but in the act.
The act it is
In the act, there is. That is where Mr. Chaudhary had pointed out that you need some additional qualifications.
Page 127, it says, it talks about the fixed salary, music teacher, classical teacher. It is there.
In the 2017 act.
17.
Ah, yes, 17.
No, how many posts?
But,
There will be
here,
one, say, for science teacher to graduate.
all, the number of
in a
teachers,
Provincial school, what should be the number of music?
number of teachers might depend upon the number of students.
Now it is number of students.
Yes.
That is one of the
Earlier-
challenges.
Number of student is minimum 10 for this year, then
Yes.
only one post.
Yes. The RT for,
So we
for,
not depend upon a number, suppose there is 100, there will be more music.
well, that is also provided for in the 17 Act. It is there, madam. In the 17 Act is there, how many teachers would come in as additional teachers depending on the number of students. That provision is there in the 17 Act.
All right, let Mr. Goswami conclude. Yes. Yes. Mr.
Yes,
Goswami.
Lordship, now on that deeming argument, I'll just place two judgments for your Lordship's considerations. Our deeming provision, Lordship knows that, but still for my satisfaction,
Please, please.
Lordship will kindly first take up 1997 1 SCC 326, State of Tamil Nadu. These are settled law, but I will tell the
What is the
paragraph.
point?
On the deeming clause, how the court is to give effect and what is the role of court? Citation to hold tomorrow. I'll place para 11 lordships at page 336.
Yes. Yes, please.
Section 5 and 6 of the Act of 1978 contain deeming fiction in its different clauses with purporting to omit and remove the amendments which had been introduced by the Act of 1974 in the Principal Act. The role of a provision in a statute creating legal fiction is by now well settled. When a statute creates legal fiction saying that something shall be deemed to have been done, which in fact and truth has not been done, the court has to examine and ascertain as to what purpose and between what persons such a statutory fiction is to be resorted to. Thereafter, courts have to give full effect to such statutory fiction, and it has to be carried out to its logical conclusion. In the well-known case of East End Dwellings Company Limited versus Finsbury Borough Council, Lord Asquith, while dealing with the provision of Town and Country Planning Act 1947, observed, if you are bidden to treat an imaginary state of affairs as real, you must surely, unless prohibited from doing so, also imagine as real the consequence and incidents which, if the putative state of affairs had in fact existed, must inevitably have flowed or accompanied it. The statute says you must imagine a certain state of affairs. It does not say that having done so, you must cause or permit your imagination to boggle when it comes to the inevitable corollaries of a state of affairs. That statement of law aforesaid in respect of a statutory fiction is being consistently followed by this court. Now, the other judgment in this respect, Lordships will kindly have a look at Consolidated Coffee.
Yeah, go ahead.
1983 SCC 358, para 11, page 371. Para 11, Lordships, at
Yes,
page 371.
yes, please.
I will just read from the last 1 to 6 sentence from the bottom of that page. Secondly, if Lordship has found the word secondly,
Yes.
secondly, the word deemed is used a great deal in modern legislation in different senses, and it is not that a deeming provision is every time made for the purpose of creating a fiction. A deeming provision might be made to include what is obvious or what is uncertain, or to impose for the purpose of a statute an artificial construction of a word or phrase that would not otherwise prevail. But in each case, it would be a question as to with that object the legislature has made such a deeming provision. In St. Aubin versus Attorney General, Lord Radcliffe observed thus: the word deemed is used a great deal in modern legislation. Sometimes it is used to impose the purpose of a statute an artificial construction of a word or phrase that would not otherwise prevail. Sometimes it is used to put beyond doubt a particular construction that might otherwise be uncertain. Sometimes it is used to give a comprehensive description that includes what is obvious, what is uncertain, and what is, in the ordinary sense, impossible. So therefore, Lordship, to sum up, it is our respect.
Yes.
So, Lordship, to sum up, it is our respectful submission that whether Lordships give effect to the deeming clause or even otherwise, in terms of the notifications that I have placed before your Lordships, the services of these 51 music teachers stand provincialized. So we seek a declaration. If Lordships still feel that the Act otherwise is valid, we still seek a declaration that the services of the formal notification under 10(4) be issued, and that we stand on the same footing as those 41,000 odd teachers that the state claimed to have been provincialized, because, as I have put it even earlier, the expression used in section 24 of the new Act, which says all the teachers whose services were provincialized prior to 23/9/2006, that has to be given a wider meaning to include people, to include the petitioners within that meaning. That is my respectful submission. And that is the relief we are seeking. The relief is at page 45 of our petition. I'm grateful for your Lordship's petition.
But Mr. Goswami, please look into that aspect.
Yes, that is what I would look for. Grateful, Lordships.
That we say because of the specific language used in the last sentence of section 24.
Lordship, I'm sorry, I didn't.
We are asking this again and again, particularly because of the last sentence used in section 24
Yes.
of the 2017 Act. Yes. Yes, Mr. Bhuya, you are in which item?
Item number 8, my lord. 8, 10, 12, 13, 14, and 15, my lord. We are also, my lord, they fall within the same category of music teacher, my lord. My lord, it has been extensively argued regarding the, my lord, legal position as well as the law And I am, my lord, endorsing and relying on the same argument, my lord, expressed, submitted by my learned respected senior friends, my lord. My lord, just I want to bring into notice of your lordships, my lord, two judgments, my lord, has been delivered by the learned single judge regarding the deeming clause, my lord. And even after, my lord, scraping out, or my lord, the
So in your case also, you are amongst the 214.
yes, yes, my lord, and
You
yes,
come
my,
under the 214.
my lord, and our case has also been recommended before the act was scrapped, before the act was held to be unconstitutional, my lord.
Yes.
My lord, may I, regarding the deeming clause, my lord, small judgment passed by the learned single judge, my lord, in WPC 6804/2017, my lord, that section 4, my lord, can directly come to, my lord, paragraph 3, paragraph 4, my lord, wherein, my lord, it has been interpreted that even in this case also, my lord, the judgment was delivered after the, my lord, the act was no more in force, 2011 act. And this, under the deeming clause, the benefit has been provided to the person, my lord.
Yes, which part you want to rely upon?
My lord, the paragraph 4, my lord, section 4, subsection 1 of the act, at paragraph 4, my lord, I am reading.
Hmm.
Section 4, subsection 1 of the Act of 2011 provided that the services of the employees of all eligible venture educational institution under section 3 of the Act shall be deemed to have been provincialized on the date of coming into force of the Act, and they shall become employees of the state government with effect from the date. Section 3 of the Act 2011 provided, amongst other, that the venture educational institution which are established and have been required permission or recognition or affiliation or concurrence as the case may be from the respective competent authority on or before 1/1/2006 and had a minimum enrollment of so-and-so students in the final year of so-and-so college, if it is a degree college, would be eligible for provincialized as provided in section 4(1) of the Act of 2011. Section 3(2) of the Act of 2011 further provided that in case of a degree college, the eligibility criteria specified in subsection 1 would also have to be satisfied in respect of each of the subject with or without measure as the case may be. Section 3 provided for some other eligibility criteria which the respective institution must fulfill in order to avail the benefit of section 4(1) of the Act. It is stated that, as already, my lord can skip this, paragraph 6 is important, my lord, as already noticed, section 4(1) of the Act provided that the services of the employees of the eligible venture educational institution shall be deemed to have been provincialized from the date on which the Act came into force, and from such date they become employees of the state government. The only requirement to be satisfied for the such deemed provincialization is provided under the provision to section 4(2), that is, the number of such employees serving in the venture educational institution should not exceed the number specified in the schedule to the Act. In other words, a conjoint reading of section 4, subsection 1 and the proviso to section 4, subsection 2 would lead to a conclusion that in the event an employee of an eligible venture educational institution who is within the permissible numbers prescribed in the schedule to the Act, the services of such employees stood provincialized under section 4, subsection 1 of the Act of 2011 from the given date by operation of law. Now, my lord, the other part, my lord, can. Paragraph 8 is also important, my lord. As already noticed earlier, the services of the concerned employees stood provincialized by operation of law under section 4, subsection 1 of the Act of 2011 itself, and there is no requirement of the authorities in the administrative side to further provincialize the services of the given employee. Provision to section 10 subsection 4 is merely for providing a procedure to be followed by the authorities in arriving at its conclusion as to whether the given employee is within the permissible numbers as provided in the schedule. In the event the authorities pursuant to such process arrived at a conclusion that the concerned employee is within the permissible number as provided in the schedule, there is no further requirement of issuing any administrative order for provincializing the services of the concerned employee in as much as his service already stood provincialized by operation of law under section 4 subsection 1 of the Act of 2011. Any such order that the authorities may pass would be only in the nature of an order recognizing the provincialization of the concerned employees which had already taken place by operation of law, and such order of recognition cannot be constituted to be an order provincializing his service. So, my lord, in our cases also, my lord, by operation of law, as we had been recommended, my lord, in this case also there is a recommendation, my lord, but it could not be provincialized due to some litigation, my lord.
Now, Mr. Bhuya, we
My lord.
appreciate your arguments
My
and
lord,
consider it,
My lord,
but the paragraphs you have read out,
my lord,
we may have some reservations
my lord,
because
my lord.
we don't think it can be said that it's an automatic process, but it can be said that the persons coming within the ambit of these deeming provisions
My lord,
would have a vested right to seek regularization.
my lord.
How that right is to be exercised and how it is to be implemented, that is a matter which may require some administrative.
My
But to say that on happening of these events automatically provincialized, that
Yes, yes, my
argument
lord can,
appears to be a little too far-fetched.
yes, yes, but my lord, as there is a judgment, that's why I have placed it
Alright.
before my lord, my lord.
Anything else you want to say?
No, my lord, and regarding the other part, my lord, my learned friend has already argued that the classification and article, this is a clear violation of article 14 and 16, my lord. That has already argued because we have been similarly situated. There is no distinction between our group and the group, my lord, which has already been provincialized. Only, my lord, what the government has done.
Is there anything new?
No,
you
my
want
lord.
to argue? What Mr.
No, my lord,
Goswami
one
might-
thing is there in my petition, I have argued, my lord, a law which they have made prospectively is now affecting us, my lord, retrospectively and by taking our substantive right, my lord. Now,
What do you have to say on this
What-
question we have put to Mr. Goswami?
regarding the division bench.
When the government came forward seeking a clarification
My lord.
to protect, they did not include the claims of persons like your clients.
My lord.
You are aware of it, you did nothing about it.
No, my
The
lord, that,
review
yes.
Order did not cover you.
That is admitted, my lord. Review order did not cover us, my lord. What has happened, my lord, when the original writ petition was going on, my lord, was put into challenge by the, my lord, the state has come up with an additional affidavit that there is some, my lord, fault in the act. So therefore, we are going to
So that
withdraw,
you've seen, that-
my lord. That is the stand of the government,
Yeah,
but
the review order, para 19.
yes, my lord, I have
You are
gone
telling
through.
how the order was passed on
Because-
23rd of September.
Because, my lord, as we were not a party in the proceeding, my lord, and we, my lord, that.
But when the act was struck down, then also you are not.
No, we were not party, my lord. Not a single person, my lord, who were, my lord, in the process of provincialization, nobody was heard, my lord. This is a judgment which was passed, my lord, without hearing us also,
Do
my
you
lord.
think some clarification was required to be taken in the review petition after you became aware?
My lord, with my very limited knowledge, my lord, and as we are now before my lordships, my lord, that clarification, my lord, can also come up as my lordship has the equal strength, my lord. With my limited knowledge, my lord, what I am respectfully submitting, my lord.
Not about strength or weakness.
My lord,
Anyway, is that your answer?
my lord, yes, my lord. Obliged, my lord.
So anything else between 6 to 15? Any other matter?
Item 11, I am appearing.
Item number before that, item number 9, madam. I am,
All right.
I am adopting all the submission of my learned friend Goswami.
1 minute. What is, they are also music teachers?
Yes, my lord, all are, except my lord, the only one, the list which was prepared, my lord, except petition number 12 and 23, my lord.
Just 1 minute. 1 minute.
My lord.
You did.
9.
Yes. Yes.
My lord, except petitioner number 12 and 23, my lord. All the petitioner are included in the list which was prepared, my lord, 214, my lord.
Petition numbers 12 and
23, my lord.
the list submitted by the
List submitted, my lord, by the authority, my lord, that is, lordship will find in my petition, my lord. It is submitted by the, my lord, Director of Secondary Education of Assam, Kahilipara, to the Secretary to the Government of Assam Education Secondary Department, this one. Dated, my lord, 6 June 2016.
all right. Yes.
My lord, regarding other submission, I adopted all submission
So
made.
what happens to 12 and 13? They are not 12 and 23?
My lord, they have stated they later on, my lord, submitted representation before the authority, my lord. But what is the consideration? They are not. Another thing, my lord, I would like to, my lord, point out, my lord, I have filed affidavit in opposition filed by the, my lord, respondent number 4 on 18/11/2020. And in this affidavit, my lord, I have submitted document regarding the creation of the post, my lord. Lordship may kindly see page 22 in my affidavit in opposition.
Affidavit in opposition.
Yes, my lord.
You are
I
the petitioner,
submitted-
is it not? You filed affidavit in opposition against the writ petition.
Yes, my lord. Filed by the respondent number 4.
Who has filed the writ petition?
I am filed the,
And you have also filed the.
no, my lord, against the respondent number 4 of the
Rejoinder.
affidavit in reply, man. Sorry, man. Reply.
Yes. What is there? in-
Lordship may kindly see page 22 of my reply, my lord. This is the letter dated, my lord, 24 August 2016, man. It is from the Undersecretary to the Government of Assam Secondary Education Department, addressed to the Director of Secondary Education, Assam Kahilipara, my lord.
That we have seen already.
Yes, my lord. I am directed to refer to your letter cited above and request you to furnish the total financing implication and budget provision for creation of proposed 214 number of post of music teacher for provincialization of service of the music teacher. So that exercise was also, my lord, earlier done.
Yes.
So in support of my deeming provision, my lord, this, my lord, government has already taken a decision, my lord, for creation of the post.
But you have clubbed in people who are differently situated, 12 and 23.
No, that's why, my lord, I pointed out before your lordship. My lord, stated in my writ petition, I have submitted the representation before that, my lord, I clarify, my lord.
Anything else?
My lordship will find in my writ petition, my lord, page 28, para 30.
All right.
Lordship. This is my humble submission. Most of that.
Because the item 14.
Lordship, item 11, Lordship. Lordship. Lordship, we are also music teachers and we had been appointed during the period of 2001 to 2004. So we had completed that minimum duration period, and Lordship, as regards the other arguments, my learned seniors have already made their substantial arguments, Lord, as regards the other issues, Lordship, and our names were also recommended regarding 214 creation of 214 posts, our names featured therein. Subsequently, Lordship, due to the developments wherein the act was struck down, our services were not provincialized. Regarding the submissions, Lordship, my learned seniors have
covered the case, Lordship. I adopt the same.
Yes,
I
we
adopt-
adopt.
I adopt the same because Lordship, they have, I have nothing substantial to add to their arguments. The issues have been covered by them. The only thing is, our names were also there in the list, 214, creation of 214 points. But for the judgment wherein the act was struck down, our services were not provincialized, and under the new act, the conditions therein imposed does not make us qualify for provincialization. But under the earlier act, our names were done, forwarded, but not processed to
As
attend
per
it
the
final.
deeming provision,
Lordship.
your services were deemed to have been,
Provincialized under the 2011,
which has now been taken away.
taken away. Lordship. Obliged.
So that's all for 6 to 15, is it? 6 to 15. Yes.
Obliged.
So we move on to group 2.
Item 16, ma'am.
Yes.
In this case, my lord, we have challenged the proviso of section 3(1) Roman 1, my lord.
Yes.
My lord, our basic challenge made in this case, my lord,
Let us see section 3(1) Roman 1.
my lord. My lord, page 108, my lord, in the books. My lord, got it?
Yes.
Well, the section 3 eligibility criteria for selection of educational institution for provincialization of services of teachers tutors. Subject to the provisions of Article 30 of the Constitution of India, the following categories of venture educational institutions shall be eligible for being considered for provincialization of the services of their teachers and tutors. The venture educational institutions which have been established and had obtained the required permission, recognition, affiliation, concurrence, as the case may be, required for the concerned institution for the respective competent authority or authorities on or before 1/1/2006, provided that the permission for first year SS clauses in respect of higher secondary school concurrence for our is last part. Degree colleges
3(1)
is
Roman 1 provided, yes. Please
Yes,
read,
ma'am.
provided that.
provided that the permission for first year SS clauses in respect of
Matching
immaterial.
in our record. Section 3, numerical 1, subsection Roman 1. What is the proviso? Read?
Lordship is,
Provided the provided
Lordship is
further
having
that
the repetition or the
No,
book?
we have our own compilation.
No, there was an
Get it?
amendment made, madam.
Here's the notification.
There was an amendment in the year 2018 to the original act.
Oh, I thought that also.
1 minute.
After that, before we put this particular provision. No, no, it's okay.
Then you say.
In my writ petition, my lord, 114 page number.
You must say it will be amended. Yes,
But that's the provided further that the order for such permission, recognition and concurrence shall have to be issued on or before 1/1/2006, and any order issued thereafter with any retrospective effect shall not be considered for the purpose of provincialization of services of any teachers and tutors as the case may be of the institution. Or agree by that proviso, my lord.
yes.
In this regard, my lord, we have taken the basic plea, the discrimination has been meted out in respect of the present petitioners and the persons who have similarly situated persons who have already been.
Was it also one of the grounds in the earlier round that some cutoff date has been fixed? Learned single
Yes,
division bench has
Yes,
found
madam.
that it was faulty.
yes.
There was a fault line.
Yes,
Same thing has been repeated.
yes.
We have given. But here a little difference has been made. There we said about the entire institution getting the recognition of the affiliation. Here we have restricted the first year when the course starts.
But the touchstone will be the same. The criteria will be.
Whether 1/1/2006 can be the cutoff date or not. That,
Earlier, the division benches.
that was not my earlier division bench actually did not decide on the issues. Only opinions were given, and when the state said that we are repealing it or we are relooking into it when we admitted mistakes on other parts where the educational
That's correct. The division benches extensively noted the arguments on such count
yes.
and then held the act was unconstitutional. That is the reason we were asking. Once there is a finding that it is unconstitutional and the elaborate reasonings are not given, it is mostly on the basis of a concession by the state. We'll have to presume that the submissions have been accepted. What is the other way out? See, the earlier judgment is very important
Yes.
because it is not a clean case of striking down of a statute. We cannot and we don't intend to comment on that judgment, but we have to look at it to figure out or to cull out the real meaning which can be infused in the present batch of petitions. To that extent, we'll have to do this exercise. And with that end in view, the judgment was examined. You are right. That reason has not directly been given in the division bench judgment. But then there is a finding that the act is unconstitutional.
Yes.
Now that finding comes in after the submissions, but it is mostly on the basis of the affidavit and concession made by the learned advocate general, additional advocate general. And then the division benches observed that this is in the realm of domain of the legislature. Now, what we are trying to figure out is that was it a ground on which the act was declared as unconstitutional?
It's 1/1/2006.
It is the mechanics are insertion of a cutoff date without any intelligible differential. If that appears to be the argument of this senior counsel, Mr. Datta.
Yes.
Late Mr. Datta, that this is one of the reasons why the act is invalid. And the division bench has extensively noted the arguments and then come to a finding that the act is unconstitutional. So you have to assist us in arriving at this. Maybe Mr. Das will do it. Whether Mr. Das, we are trying to understand the.
Yeah, I understand. My lord, what was put to Chaudhary and my learned friend Swami regarding I have not taken that benefit or dimming provision. Let me be very clear.
You have not taken
The provision of dimming.
Uh-huh.
I know once it is because I argued once before court number 1 when I'm an AG, repealing means it goes, everything goes. You cannot take the help of those acts, of the earlier act. That we were put, if that be the case, then I have to be out from this case. I cannot take a different stand which I have taken in that case. I have been hearing, but that is not my case. Because that is not my case, I am challenging 2017. And your lordship is putting a query on a retroactive effect, which has been passed. But there are few acts which I will show when my turn comes. 1977 Act, what was the object? Object to be achieved. 1977, 79, then thereafter 2011, which is no more, and is 2017 Act. Now, my lord, your lordship was putting
No,
a query.
we'll hear the argument. You see, the reason why this question is being put repeatedly, we'll disclose it.
Yes.
There are judgments which says if an act is declared to be unconstitutional, the action taken under those acts do not become null and void unless there is a specific order to that effect. So there is really no need for either the court or the state to come and seek a clarification that what will happen to the action we have taken earlier under that act. There is no need for that. There are judgments of 1978, 77, which is clear on this point that if an act is struck down, it does not make the action taken under the act as nugatory. There could be appointments made under the repealed act, struck down act. That appointment may lead to further orders being passed. All these things cannot be set at naught. So it does not take away the action already taken. That's settled law. So there is no scope of making any other interpretation on that point. Right. But here what has happened is the state has come asking that please allow us to protect it. That was automatically protected. The court says, no, will not allow you to protect. You make your legislation, but don't disturb. Correct. Then a legislation comes with a saving and repeal clause at section 24, which is worded in the manner you have seen.
Yes.
This creates more trouble than it solves. And therefore, at some stage, these arguments will be heavily based on principles enunciated under Article 14 of the Constitution. We have to look at it. But the difficulty is, when you look at the judgments of Supreme Court as to the impact of an act which is repealed or struck down by the court, these are pretty well-defined contours at the moment. We are finding that the observations made in the review order does not straight away fit into those contours. And therefore, it has to be interpreted by this court. It has to be interpreted. This interpretation will have an impact. It is not a question of whether this court has power or not. That is not even the question. Power and jurisdiction of Reed Court is enormous. But we'll have to follow the canons of judicial discipline in interpreting the orders, judgments, and taking things forward. The state was concerned about those who had got the benefit, but the state, either by design, which we can't say, either deliberately or due to an oversight, left out those people who would have come within the dimming provision of the act. Number two, in every act, what is mentioned is those persons will be deemed to have been government servant whose services are provincialized under this act. Understandable. Where is the question of adding that or who might be in future? No, that expression is never there in any act. At least I don't know about my learned, but I have not seen. Anybody who commits an offense under this act will be punishable. Or he will also be punishable if he commits that act in future. Is it not a completely redundant?
My lord, why they have, why I am telling you, your lordship, why they have done it. I have also not come across that particular the word which they have inserted there under some 4D or 4J, which my learned friend Chaudhary has shown, or future. Only because what I found, if your lordship goes to the object and the preamble, because there were a lot of mushrooming of schools. So there was a ban, there was a background. 1995 till 2005, there was a ban. They doesn't want again to come up. There are so many schools. There was a ban. Now ban was lifted from 2005. And this act kindly see the object. I will show it the object to be achieved, the purpose behind. They will not further, they will not provincialize any more school. Whatever there, about 42,000 or 30,000 school which was left out, their aim was to bring under the control and management of the government.
Understood, Mr. Das, but that's not the query. What we are asking is something else. This act, this provision, section 2H and 4.1 clearly had futuristic.
No, I know,
provisions
but
in the act.
so my lord, that's why
So
I'm
if
saying.
there is a futuristic.
No, my lord,
provision-
I am not taking the help of that dimming.
No.
That's not my case.
No, it's not a
Yeah.
question of you
Yeah.
taking or not
Yes.
taking. We are at the moment on an interpretation of law. What your clients are seeking or who is, that's another matter. This is a act which clearly had a futuristic provision. It's understood that
Yes,
anybody
I've
who is
seen that.
regularized under this act will be treated as government servant. And also those persons who are likely to be or is going to be regularized in the future will also be. That means the act clearly knew that these are the people who are going to be regularized in future. A provision of the statute cannot be an empty formality. It cannot be presumed that the legislature was unaware of. the
My lord, your
implications.
lordship, for that, your lordship, immediate answer. Kindly see one judgment of the Supreme Court. When your lordship was discussing about that issue with dimming and futuristic, what is the impact of it is struck down, unconstitutional. Please see into 2022, when your
So,
lordship.
Mr. Das, we may not be able to conclude it today. My brother has a single bench.
Yes,
So up to 3:30 we'll continue. But tomorrow when you resume,
I'm the only difficulty.
you are not
I
there.
was sitting from the morning. I didn't disturb your lordship because lordship is going serially. Your lordship was taking up the matter. My turn comes 28th, I think, the group 4. So I didn't want to go.
No, are you available tomorrow?
Tomorrow it will be difficult. I am not there. Mr. Kalita will be there.
Mr. Barbara is there, maybe.
Yes. Yeah.
Mr. Barbara, we are facing a difficulty in one area. Whenever you argue, we'll request you to please address the court on that.
Yes.
I'll rephrase it once again. The thrust of the argument, so far whatever is first one group we have seen, is that the complaint is that there was some right which had accrued to us, either under the dimming clause or the fiction or whatever, which has been taken away by the subsequent act. Now, on a constitutional parameter, this is a very valid argument and the court has to examine.
Yeah,
But on the fact situation, what is apparent is that on a reading of the judgment, which we might have missed out one or two things, we find that the division bench has recorded the arguments and also given an opinion that the act was not okay, but has largely declared it unconstitutional by taking note of the concession of the state. Then the state was given the liberty to reenact, repeal the earlier law, and at that stage, the state comes to the court saying that allow us to protect the action taken by the government under the earlier act, meaning thereby we have provincialized the service of 41,000 something. Now, we say that law is well settled that any action taken under a repealed act is automatically protected. There was perhaps no need for the state to come.
And general clauses like section 6 takes care of it.
General clause is there. But the state has come, and as we see, the court has declined. But only said that don't disturb their services. So it is in this backdrop now the question is raised that we are protectives, but the state has not taken up our cause. So now you please protect us. That is the argument which is coming in. So we are trying to understand how do we see these two developments, because it is not a case purely where the court has struck down the act. The government has repealed it and brought a new enactment. but has put the onus on the court, saying that the court has struck down. And this was the language of the court, which does not appear to be entirely correct. The court did not say do this, do that. The court only says, these people you don't discontinue, otherwise we have nothing to say. Right. Now, unless we clearly understand this, it may not be correct to apply the present law. And particularly some of the beneficiaries, they remain silent. Now, if they are arguing, if they are assailing the provisions of the Act on fact situation, urging factual assertions, then of course this will be a relevant factor that they did not challenge it. After the Act was struck down, they never came forward to protect their, or even not even a review anywhere. So that matter attained finality. So today, this court will have to add words to para 19 of the review order, whether that would be permissible or not.
So what I think, my lord, the grouping has lessened the burden of this court, my lord. I am here to assist. Your lordship needn't go through the factum of the 83 odd cases, my lord. And definitely. And there are, he is also challenging section 3(1), Roman 4, Roman 9. So these groupings will help you, my lord. It's not that lordship will have to go into the individual nitty-gritty of 83 persons, and we are here to save time. To come about the, my lord, the repealed act, I think the division bench arguments assailing the 2011 act didn't have the occasion to go far, because suddenly government came up with a concession, rather admission, and then it broke down. It broke down. Anyway, that was a verdict, and a new act comes into place, 2017. It was slightly hazy, but the 2018 amendments brought, my lord, all obnoxious provisions. Why most of these 80 petitioners are here before your lordships, my lord. And there, my lord, I was endeavoring to submit, I will continue, that the vices of the repealed act, since repealed act 2011, in the new act also the vices, some of the vices remain.
That is another question we asked Mr. Majumdar.
That's where I am going to argue. And my
Because
lord,
these are the arguments which were advanced, and the division bench seems to have agreed with those arguments.
Yes.
no doubt about it.
And the act was declared to be unconstitutional.
Had it not been on concession, I think many other things and clauses would have been discussed in that judgment, but there was no opportunity, no occasion for that division bench. But with the existing amendments as brought in by 2018 amendment, I will, my lord.
That is precisely correct, but should we presume that the division bench had taken note of these and on these grounds held that the act is unconstitutional, then by applying the ratio of division bench judgment, is this present
Two major things the government was very prompt in admitting. That repugnancy with respect to three of the acts, and then not doing the reservation part. And there the entire arguments broke down pretty basically in 2011. Now there were other things also. Now your lordship will have to render a comprehensive judgment, my lord, on various clauses under challenge. Illegality, veracity, classification, irrationality, and then nexus with the object, and all these things, my lord.
No, that's why I was saying, man, object to be achieved is very important. Nexus.
Yes.
Because if your lordship sees section 3, that is 1/1/2006, they have taken from the old act 2011. Now there what they have done, their provision has been given a cutoff date, saying that provided whatever is been only would be no retrospective effect. So certain, that's why I'm saying 1995, 2005, there is a reason of saying behind the code. There are a lot of applications filed prior to that. So homework by a division bench earlier, they said which are the school, which they applied. So that's not our fault, because what you have done, some school like the 42,000, how they came, some applications were filed prior to that. Now by bringing that proviso, you have made a classification, we are out. Certain, how? Because they said that 1/1/2006, but with retrospective effect, government has said some recognition is given in 2008 with effect from. They said no, we have put a proviso, so you are out basically. You are out. Whichever was existing recognition, approval, concurrence is 1/1/2006 prior to that. So now those teachers, that's why I'm saying my argument which Mr. Goswami said, there is a intelligent differentiator, even those teachers, 42,000 teachers are still continuing. Still you are continuing those teachers.
Correct.
And those teachers, my lord, will see. I have asked my client, what about those teachers? Those teachers also with effect from, they are continuing on the same pedestal.
So the question will
That's
be
because
whether
there
the
is a
groups,
para 19
similarly
of
circumstanced
No,
left out, that will be one
Yes.
area for your lordship.
But your lordship will please keep in mind, that application, review application was filed by the state. Because once the act was struck down, that means all teachers fall down. But what will happen to those schools and colleges? They have to continue with some teachers. That's why they came with an application. And they said, okay, you continue with those teachers which has been provincialized, 42,000 continued. Our bad luck, because that was struck down. In our case, everything was done eligible. It was e-portal also, everything was, but what this striking down of the entire act, we are out. And further, proviso, by bringing proviso, again we are out. So now, my lord, a proviso, that's the first part. First part, if your lordship says that, okay, proviso, you can't do it. Other part, you have segregated. One is assistant teacher, one is tutor. Then that has to be looked into it. What is the role of a tutor? What is the role of an assistant teacher? And now what you said, father, that we have to go for B.Ed, all those tutor, and we are giving you 5 years time. Once you qualify 5 years, then you will come under the purview of assistant teacher. So these things are there. Today, these teachers, 20 years of service in the school. Now in this school, my lord, earlier, what was the percentage? Now, if you want to get an admission to B.Ed, 55% is required. How can we do it, 55%? We don't have that 55% also to get admission to B.Ed colleges. They said, you will be classified as an assistant teacher, now as a tutor. So why this two classification you made? All this has to be looked into. There are other provision also which has been put to challenge.
You will be available day after tomorrow.
Day after tomorrow, yes. Day
Right,
after
will next 2-3 days, this bench is specially constituted.
Or me, my lord, item number 83, venture colleges, and I have been engaged also in some of the cases, my lord, 5, 6, 7, 8, like that. Okay.
So tomorrow we can begin with your.
I'll be here at your.
Only one we want to know when the government will start. Government also is.
They are yet to start.
Tomorrow by
That
another
we should
Petition
know.
is not finished.
Yeah, no, I know, but we should know.
1 or 2 hours will take maximum, then. Acha, Mr. Majumdar, this is a specially constituted DD,
And
so we'll not wait. We cannot wait.
today we had a discussion, my lord, if the AG could be made available day after tomorrow, my lord, he could start. My
That
lord.
you see, but otherwise we'll.
Otherwise, my lord, anybody continues, we'll have the notes ready. We will not take a date that we need to clarify on something.
Yeah,
The AG will be
What we are
prepared
saying is,
once we start.
we would like to accommodate the learned advocate general. There's no problem with that. Please understand, suddenly if somebody comes and says, don't take up the matter today.
No,
AG is
that
not
will
available,"
not, that
then
will
the
not. happen.
bench will collapse and we'll
No,
have to
what-
rise.
Even, my lord, for the purpose of in between queries falling from your lordship, there needs to be some. My lord,
No, will be,
side.
someone will be here, someone who can answer or someone who. No, only one thing we both noticed, my lord, this 1/1/2006 cutoff was not a matter of challenge in the earlier act because there the
No,
one.
it was assailed.
No, my lord, we have just gone through the judgment, my lord.
I have
What was
challenged
said was, no, that was
I
challenged
have
in
challenged
the,
that.
in the new one, it is challenged.
1/1/2006.
The earlier act, what we had said was, if there is a recognition with effect from 1/1/06 or earlier, okay. Now the challenges come that any order of recognition passed after 1/1/06, even with retrospective effect, will not be taken into consideration. That order dated 1/1/06 or later on, that part is under challenge. That we have a cutoff of 1/1/2006 was never under challenge.
Appears that you've turned a very simple mechanism into something which is akin to a rocket science. What is all these hazy
My lord,
ideas?
our affidavits show that there is a particular process in law which says that there has to be a permission, then there has to be a recognition, and then the school can continue to function.
Right?
Records show from the petitioner side recognitions come prior to
Then you
permissions.
deal with each case and pass an order, no? Why are you trying to shut them out by bringing amendments to the provisions of the statute? Thereby exposing the very statute to challenge and before the court.
Individually, even if we want to go for each of the writ petitions, my lord,
No,
consist
see,
of.
please understand.
And
You are free to do what you like. There is no difficulty. If you want to go by facts of each case, then there is a mechanism. We'll ask you that. Even in your statute, you have said subject to review.
Yes.
So the people, the 41,000, have you reviewed them? When have you reviewed? Have you followed the provisions of the act? We'll ask you these questions and we'll ask you data on that. But that's another thing. If the idea is that by bringing sweeping provisions in the act, cut off thousands of people, we may have to look at it with some degree of seriousness.
That's what I said.
Yes.
Shut us down. You cannot put-
That was what was
Well,
argued in the
otherwise,
first.
This,
the
apart
first
from
was-
element of constitutionalism involved in it, this is also a human bomb, human problem, which has to be addressed by the court, this way or that way. People who have been serving as
We have
teachers-
taken into, the act has taken into fold as much.
Of course,
as
you are yet
we
to
could have
argue.
done.
This is not the view of the,
And I understand.
just flagging an issue. If the idea is that we will not go into it, bring in sweeping provision and cut it off, we are again going back to the division bench,
Earlier division.
first division bench. Therefore, are you again going to make a concession or you are going to make us write a bigger judgment? That's the only question which will arise. Many of the things are in the same lines.
Too bad
The
legislation.
division bench has noted all these arguments, but for some reason,
There
we
was
can see.
But
there
why,
was-
my lord, I'm sorry, my lord, while deliberating before the division bench, earlier with the bench before the Honorable Chief Justice, this was a query which was put forward. I remember that was put forward. 1/1/2006. So all these applications, the schools, various schools, were prior to 1/1/2006, which was
Yes.
pending before the government. That's what we said. It was pending before the government. It's you have not done it. It was pending before the government. 2004, 2003, 1993, what you have done? What you have done? Now you brought this only to leave them aside, to not to bring under the purview of that particular 2017 by giving a proviso, which applied long back, 30 years in service, 30 years retired.
Mr. Majumdar, we are not expressing any opinion.
understand.
We are just indicating so that you can come
What
prepared
we have
and address the court. Because you have not yet argued your case, so there is no opinion this way or that way.
I'll be here tomorrow.
Petitioners are also yet to argue. So let us see how much we can
Yes,
progress
yes, ma'am.
by tomorrow, and then the idea would be to close the matter by this week. This bench is available only for this week. And we'll close it by this week.
Kindly see one judgment, my lord, of just that repealing one, 2022 SCC online, SC 130. Kindly see that judgment.
The copy available.
That's that's a para 24 of the judgment.
Okay, what does it say?
The one small paragraph, the power of a legislative body to repeal a law is co-extensive with its power to enact a law. The effect of repealing of a statute is to obliterate it completely from the records of Parliament. While repealing a statute, legislature is competent to introduce a clause saving any right, privilege, liability, penalty, act or deed duly done and any investigation, legal proceeding or remedy arising therefrom under the repeal statute. There is a distinction between declaration of a statute as unconstitutional by a court of law and the repeal of a statute by the legislature.
Precisely what
Yes.
the query.
That's what your lordship, that's why I remember the judgment was placed for division bench. I remember that's why I asked quickly bring that judgment. On declaration of a statute as unconstitutional, it becomes void ab initio. Saving past transactions are within the exclusive domain of the court. On the other hand, though the consequence of repeal is also obligation of the statute with retroactive effect on past transaction, legislature is empowered to introduce a saving clause in the repealing act. Even in cases where a saving clause is not made, the provision of General Clauses Act are applicable to central statute and principle of General Act can be made applicable statute made by state legislature as well. So this is, it reveals to state at this point Manipur legislature enacted so and so, so and so. That's the proposition of law.
Mr. Das, this is the reason why this point. Is
I
again-
know, my lord.
See, the problem here is, if you treat it as a repeal by the state legislature, then this saving and repeal clause is clearly discriminatory violative
Yes.
of Article 14. The government will say that we have followed the direction of the High Court.
I've
The
got.
High Court says, we are not getting into your repeal business. So which of the two should we follow? That's the question we are asking you. They have quoted that it's because of the High Court we are doing it. So therefore, the state will say that it is not our decision, it's the High Court order. And the High Court order is passed without hearing those affected parties, and they are not seeking a review of that order despite having come to know.
No, High Court, my lord, they filed the application.
Hmm.
What the High Court will do and comment on this, they have filed an application saying that this teacher should be continued.
But why the petitioners have not moved for modification of that order?
No, there are, when this act, they said we'll repeal this act and we'll bring a new act.
Mr. Das.
No, I have
no point in repeating again. and
No, I have got, my lord, this, so your lordship see.
Repeal
have
is
seen.
discriminatory, but we cannot hold
But
it.
I know, my lord, but there are certain cases which have been shown by my learned friend by a single bench.
That's not
That
the
I have
point.
seen.
24 of the new act prima facie indicates that they have protected a particular group while omitting the other group. Assuming that you take, there is a deeming fiction under the earlier act, they have clearly run a wedge between the two categories. Those whose services were provincialized have been protected. Those whose services were not provincialized have not been protected, although there might have been some right accruing to them. So if you look at that from that standpoint, the deeming provision appears to be discriminatory. But the state's argument could be, we don't know what they'll argue, that we are following the order of the High Court. They have mentioned it in the order of the High Court was passed on an application made by the state where they did not espouse the cause of the other group. The other group also did not espouse
But
their
that
cause.
was not the argument that was advanced. Your lordship is, please do not give a handle. That was not the argument which was advanced by the state at the relevant point of time. That was not the argument. I was there
That is a
present.
bit of a-
That was not the ground itself. They said in their affidavit that no financial constraint are there, so we will not be able to do it. That's all.
Unless you interpret section 24,
Yes.
it was going to have a ramification on the interpretation of other provisions of the statute, which are being urged, because 24 in a way qualifies the right that flows from the other provisions which are under challenge. For example, 3(1)
Yes.
proviso, etc. You cannot strike down 24 as discriminatory because the state will take a stand that we have done what the court has directed. The court will say that if there was an order prejudicial, why didn't you come for modification of it? We are just trying to see through the stages. Of course, purely on a constitutional point of view, the matter can be examined. That is there. That the REIT court, this court will have the power to do it. But the moment you entangle the matter with the facts, the background facts, which are inextricably connected with this fact that there is an order in the review petition, which has practically been quoted in para 24, in section 24, then it may create a legal obstacle. We are trying to figure out how to handle this.
We'll give an answer
You
to it
could
also.
render some assistance, we'll